Here that your lordship will not know.
চলো
দাঁড়া জজ সাহেব ওঠেনি এখন।
goes against the gateways, which I had mentioned yesterday. Started the demolition.
Who is your other side?
ওগুলো তো ওর ফাইলে চলে গেছে। তোর ফাইল কোথায়? হ্যাঁ, ওই ফাইলটা শুরু হয়ে গেছে। He was served in WhatsApp. Even he is not engaged by the Ministry of Law and Justice also. No one is engaged. Just he was engaged. He was appearing the single bench.
Affidavit of service.
There was
My lord,
engagement,
I'm
single
really
bench.
sorry
That's why he was served.
to take up this time.
Until your lordship knows that no one, until and unless engaged by the Ministry of Law and Justice, he cannot appear.
But they are being throwing out, they are being removed, no?
Demolition is taking place.
In the morning, he's only over telephone. He requested me. Mr. Sonajit Ghosh over telephone. He requested me. Not, this is the situation. He was served by
1.85 crores.
My
Outstanding.
lord, that they have not shown any calculation. My lord, the background of the case is these are plots where license fees were fixed based on land value. My lord,
You are license holder of plots of land.
plots at Shialda siding.
And now you have made any construction on that?
No, my lord, these were old sheds since before even 1980s.
So now what is
My lord,
you order was passed on 16th May.
16th.
Then what demolition they are doing? How many plots are there? How many persons are here?
My lord, originally the writ petitioners were numbering about 48, but in this appeal, my lord, there are only 28 who have come forward with this appeal. These were the old British time structures which were there, where all the materials which used to come in were stored.
Secured the amount. You secured amount.
My lord, at that point of time, what had happened?
You cannot eat the cake and have the topping
My lord, I'm not denying that I'm not willing to pay. The original writ petitions, the two writ petitions, are with regard to the calculation of the amount. What the railways are doing is
They have enhanced it at a higher rate and more frequently than you would like. As a licensor, they are entitled to do it.
Lordship, I'm not denying it. Because, and they stopped taking payment from 2010. My lord, we have
because you wanted to pay at a lower rate, Mr. Bose.
My lord, even during the pendency of the writ petition last year, my lord, we wanted to settle the matter and pay them.
You are running any business from there?
Lordship.
How many plots are there?
My lord, at this point,
there are 25 persons.
My lord, at this, these 25 are only operating at that. And this amount which has been shown through a notes of argument, my lord, they have not shown any calculation which portion and who is to pay what amount. My lord, as even for the first writ petitioner, he doesn't know exactly what his exact amount is.
When it is done, no date, nothing, we don't know.
My lord, it was sent today.
It was.
My lord,
there are cameras noting the date and time the snap was taken.
My lord,
order was passed on 16th May. Today we are on 20th.
Lordship.
When was these photographs taken?
Today.
But how will we know?
My lord, I can show you the.
That is your WhatsApp message, sir. Where is the indication that this was taken today?
My lord,
your submission is demolition is going on. Then there has to be a live photograph of
my lord, unfortunately, my lord, most of them do know how to use a smartphone,
I
but-
don't know.
but the
we
date and
analyst
stamp and
know
watermark.
কি করে।
Newspaper. You don't know how to get the date.
Well, that is my fault. That is my fault, not my client's.
How can we help you then?
My lord, let them at least come up with
We
the,
cannot make an unimplement, we cannot pass any order which we cannot implement.
my lord, stay.
Today at 12:30, we will pass an order, don't demolish. They will come and tell us tomorrow that before you pass the order, we have demolished.
My lord, I had prayed for stay of the operation of this order,
Huh.
impugned order under challenge.
Useful.
You are also not.
Who appears for rail? Who
Four
appears-
plots have been, the first 4 plots have been broken.
First four.
First 4.
I'm also appearing on behalf of the Union of.
No, who is your senior? Tell us, na.
Is it engaged the senior? Sonajit Ghosh is all along is that Sonajit Ghosh also appearing on behalf
No,
of
he has not come. So somebody has to appear, na.
today.
Today somebody has to appear before us. We want to know. You take instruction then whether their demolition work is going on today or not.
I can take instruction if it is keep tomorrow.
We will keep it tomorrow, but we want that if demolition is not going on, you start demolition after we hear the matter. But we cannot pass that order because we do not know what is the present status. This is our difficulty.
WhatsApp video live video though. Live video though.
By today I can
আমাকে দাও ওরে
Who is your senior counsel? Who appears for railways?
Sonajit Ghosh also appears. Souvik Nonji
how
also
will we
appears.
know tomorrow Sonojit Ghosh will again be absent? How will we know?
Souvik Nonji also is there.
I don't know. That is your trouble then.
The Sonajit Ghosh will appear.
Please take instructions. Whoever appears, at least apprise us
Yes,
of
I
what
will
the
take
situation is.
instruction today.
Mr. Bose,
Mr.
wait till
Sonajit Ghosh
tomorrow.
will
But if,
today instructed
4
me he will not
becomes
come.
20,
He will come tomorrow.
my lord, then let there be a stay only for today. Only for today. Only for today.
Without being satisfied that whether your plot has been touched or not, we cannot stop them from proceeding against the other plot.
My
You
lord,
yourself have submitted
Even
20.
if there is, my lord, if I may be permitted to pray, even if there is a stay for the operation of the order, then they will have to, or they can stay their hand in that notice.
If we pass an order, it has to be complied with. We will not leave an avenue wherein persons will come and say that after the order was passed, no demolition was done. All demolished in the morning.
My
It
lord,
was incumbent upon you to be more conscious about the facts and to able
then,
protection. We
my
gave
lord, may
you
I be permitted to pray a stay of the operation of this notice, annexure F, volume 3, page 521, volume 3, lordship.
Mister, you should have also taken instruction that what is presently going on.
Actually, what
Should have
happened
taken
today
the-
morning, I have been informed. No one engaged from the Ministry of Law and Justice. Until Ministry of Law and Justice engage anyone, your lordship can direct any lawyer to engage. Thereafter, instruction may be.
My lord, thankfully, he was my batchmate, so I didn't let him leave.
It doesn't say demolition.
My lord,
It says
they will
possession.
take,
Vacant will be thrown out.
lordship, demolition is part of. My lord, railways always adds its own to any kind of order. Only for today. And if it is taken up tomorrow morning,
You deposit the money. We grant you the
but
stay.
my lord, 1 crore 85, but it is not for 28 people, it is for all the plots.
Mr. Bose, we are not being able to understand the matter in the absence of the railways. You show your bona fide.
My lord,
Put in the
if I may
1.85.
suggest, 50,000 per writ
Mr.
petition.
Bose, we are not open to bargaining.
No, my lord, only these writ petitioners who are
How do we
appearing.
know how much each writ petitioner has due?
My
What
lord,
is
we
the
really
against
don't
them?
know because they have not raised any bills. We've been wanting to, my lord, were carrying.
Tomorrow it will be the first matter. 25 you are here. In the meantime, you ascertain whether your 25 plots have been they have done anything or not. Come and tell us tomorrow morning. In the meantime, we are not being able to engage any lawyer at this stage. But you please do not sleep. You instruct your what is
Yes,
going on. We must know the factual backdrop tomorrow morning.
Yes, ma'am. In the meantime, I will.
My lord, the per plot amount this is, I'm not bargaining. Per plot
You
amount
also
as
come
ad hoc
tomorrow.
payment
Come
of
tomorrow with the
50,000 per plot.
calculation
That's
in respect of these 25%. What is the total amount payable?
Yes, ma'am.
License fee, what is the total amount payable?
Yes, ma'am.
চলো কালকে
20. My lord, would my learned friend be taking an undertaking that no further demolition be carried out today?
Sir, we cannot pass that order, na? How can we pass that? You're not being able to satisfy us whether your plot has been touched or not. If your plot has not been touched, we are not with
My lord,
concerned
10
with the
minutes at 2 p.m. My lord, after recess, because I understand there is an assigned matter.
Hmm. We have an
Maybe,
answer.
maybe come back at
Come tomorrow. Come tomorrow. In the meantime, you take all instruction. Come back tomorrow. It is a question of taking possession. If possession is taken, no, another person is not being, there is no,
but my writ petition would and my appeal would become infructuous, totally infructuous. কি বলছো?
দেখাতেই পাচ্ছি। Yes,
Well,
well,
only for today. I'm just praying only for today since I'm coming back tomorrow morning.
Bose, come back tomorrow. Come back tomorrow morning.
Well, the affidavit of service be kept on record.
we will take it back. Take it. হ্যাঁ ওইগুলো ওকে দিয়ে
I'm ready.
but tomorrow if you are not with the instruction we will proceed
At the
and whatever documents you have any further documents you gather make a supplementary affidavit and file it tomorrow with an advance copy to him
lordship.
ডাকো judgment ডাকো
দিয়ে দিস তো। ওই শুনুন।
এগুলো হচ্ছে মনোপলি
We've allowed your appeal, Mr. Bhattacharya. But I'll just read two operative paragraphs. Having set aside the impugned order, we are now faced with a rather onerous task of balancing the rights of the parties. ECL has not been in a position to supply coal, which it ought to have supplied to the predecessor of the appellants herein, due to a change in their policy. We have not been apprised of the price of coal at the material time or even thereafter, nor of the cost of lifting such coal by the appellants, by either of the parties. It could be an empty formality to pass an unenforceable order directing ECL to supply the balance 17,900 metric tons. And then the quantum of compensation would, however, depend upon the peculiar facts of each case, and no straitjacket formula can be evolved. The appellants have suffered distraught pain due to the stonewalled response from an apathetic administration. They have been deprived of their claim for a substantial period of time, which on its own merit is a matter of great suffering. Since it is an admitted position that ECL had acquired the land of Badol in the year 1980 and the litigation had continued for more than 32 years, we are of the view that ends of justice would be met if ECL is directed to pay a lump sum amount of 25 lakhs to the appellants.
My lord, I'm praying
This-
for operation of the
this
order.
Payment is to be made within a period of 6 weeks from date.
Praying for operation of this order.
What prefer? Go to the Supreme Court you want.
Have your lordship's kind leave, my lord. Otherwise,
But you are
From
praying for stay of operation. এই লিখে নাও। এই কথাটা
You are appearing for ECL, Council for Eastern Conference Limited, bracket ECL, is for operation, stay of operation of the judgment. Such prayer is
turn, my lord.
we would be coming back at 2:15 because
Look.
2:15.
Obliged শোনা
My lord.
We are making an endeavor to come back as early as possible.
Let's will your lordships kindly grant me leave to make a mentioning, my lord.
আচ্ছা, আজকের কেসটা 17 নম্বরে লিস্টেড আছে। হ্যাঁ, আজকের কেসটা 17 নম্বরে লিস্টেড আছে। তো আজ হয়তো কিছু একটা ফলাফল আসবে। তো অনেকেই বলছিল যে এর সঙ্গে কি 22 স্টেট 23 স্টেটের ইফেক্ট পড়বে কিনা, এই প্রশ্নটা অনেকের মনেই ছিল। তো আজকে কি জাজমেন্ট আসে না হলে পর্যন্ত কিছু বোঝা যাচ্ছে না যে কি হতে পারে বা কি হতে চলেছে। কখন হবে বলতে দুটোর থেকে শুরু হওয়ার কথা। দুটোর থেকে শুরু হওয়ার কথা। দুটোর থেকে শুরু হওয়ার কথা। আপনাদের যদি কোনো প্রশ্ন থাকে অবশ্যই করতে পারেন কমেন্ট বক্সে। যদি কোনো প্রশ্ন থাকে আমি চেষ্টা করব যদি জানা থাকে তার উত্তর দেওয়ার। প্রণব মাহাতো, শিখা সরকার, শাখিন সাথী, ভীম বলছে কখন 17 নম্বরের লিস্টেড আছে, দুটোর থেকে শুরু হওয়ার কথা আছে। শেয়ার করতে পারেন বিভিন্ন জায়গায়। শুরু হবে, এখনই শুরু হবে, ঠিক আছে। বিক্রম বলছে, কি বলছে বিক্রম, নিউ টেট হবে নাকি ভোটের আগে? হ্যাঁ, নতুন টেট তো হবেই অবশ্যই, আগেই বলেছি। যারা এখন বলছে আমি অনেক আগেই বলে রেখেছি, আমি অনেক আগেই বলেছিলাম। এই ভোটের আগে একটা টেট তো নেবেই, তো সেই কথা মতো তো অবশ্যই ভোটের আগে একটা টেট হবেই। সেলফিশ বলছে এটার রেজাল্ট কি মনে হচ্ছে দাদা? এই আজকের মামলাটার কথা বলছেন তো? আজকের এই 32,000-এর কথা বলছেন? দেখুন, এখনই স্পষ্টভাবে বলা যাচ্ছে না যে কি হবে কি না হবে, তবে এটুকু মোটামুটি পর্যবেক্ষণ থেকে যা বোঝা যাচ্ছে, তাতে যেটুকু জানা যাচ্ছে আইনজীবীদের কাছ থেকে, আমি আইনজীবীদের মতামত বলছি। আইনজীবীদের মতে এটা যে পুরোপুরি যেমন 26,000 পুরো প্যানেল ক্যান্সেল হয়ে গেল, পুরো প্যানেল ধরে, এটা ক্যান্সেল হবে কিনা সেটা নিয়ে একটু প্রশ্নচিহ্ন আছে। ক্যান্সেল পুরোটা নাও হতে পারে। আচ্ছা, পায়েলি প্রামাণিক বলছে যাদের এজ আপার টেট পাস আছে, যাদের আগে আপার টেট পাস আছে, তাদের কি এবার দিতে হবে? আপার টেটে তো ওরকম কোনো ব্যাপার নেই, যে একবার পাস করলে লাইফ টাইম সার্টিফিকেট, ওটা শুধু টেটের ক্ষেত্রে, ওটা তো শুধুমাত্র প্রাইমারি টেটের ক্ষেত্রে একবার পাস করলে লাইফ টাইম সার্টিফিকেট। আপার টেটে ওরকম কোনো গল্প আছে নাকি? প্রাইমারির ক্ষেত্রে ওই গল্পটা থাকে, প্রাইমারি রিক্রুটমেন্টের ক্ষেত্রে। এখানে কতজন আছেন যারা প্রাইমারি টেটে পাস করে আছেন 22 টেটে? একটু হাত তুলবেন, কতজন আছেন যারা প্রাইমারি টেটে পাস করে আছেন? সৌরভ ব্যানার্জি বলছে শুনানি কখন কখন হবে? শুনানি এখনই হবে, হ্যাঁ এখনই শুরু হবে, এখনই শুরু হবে, দূর থেকে শুরু হওয়ার কথা, এখনই শুরু হবে। সৌমিত্র গায়ন বলছে আপারের ক্ষেত্রে এক নিয়ম। আচ্ছা, এখানে 22 টেট পাস করে আছেন কে কে? 22 টেট প্রাইমারি টেট। আচ্ছা, সুদীপ চ্যাটার্জি পাস করে আছে, পিয়ালি প্রামাণিক পাস করে আছে, দুজন পাওয়া গেল। এখানে যারা উপস্থিত আছে 22 টেট পাস করে আছে। আচ্ছা এখানে, আচ্ছা সেলফ স্টাডি পাস করে আছে। আচ্ছা, যারা আপনার আছেন এখানে ওই মানে টেট বাদে, আফতারুল সরকার পাস করে আছে, বিধান পাস করে আছে। আচ্ছা এখানে আচ্ছা যারা আছে অবশ্যই বলুন। তার পাশাপাশি এখানে টেট বাদে যেমন পুলিশের কেউ আছেন যারা পুলিশ অ্যাসপিরিয়েন্ট, মানে পুলিশের পরীক্ষার জন্য প্রস্তুতি নিচ্ছেন, পুলিশ পিএসসি। আচ্ছা, কৌশিক চক্রবর্তী পাস করে আছে, পুলিশ। আচ্ছা বলছে আমি ফেইল। আচ্ছা, কৌশিক চক্রবর্তী পাস করে আছে। আচ্ছা, তোমার পুলিশ পিএসসি, পুলিশ আর পিএসসিতে আছে। সৌমিত্র গায়ন আছে পিএসসির জন্য প্রিপারেশন নিচ্ছে। আচ্ছা আচ্ছা, রেলের জন্য প্রিপারেশন নিচ্ছে কতজন আছে এখানে? সুদীপ চ্যাটার্জি পিএসসির জন্য প্রিপারেশন নিচ্ছে। আচ্ছা, এখানে ফুড এসআই পরীক্ষা দিয়েছিল কতজন আছে? ফুড এসআই এর 90+ নম্বর আছে কতজনের? ফুড এসআই এর 90+ নম্বর আছে কতজনের দেখি শুনি। ফুড এসআই পরীক্ষা দিয়েছিল, যেটা আমরা প্রশ্ন আউটের জন্য যেটা কেস চলছে, ওখানে 90+ নম্বর কতজনের আছে এখানে? আছে কেউ ফুড এসআই দিয়েছিল? আচ্ছা, আফতারুল সরকারের আছে 80+ আছে। আচ্ছা, রফিক আলম ভাইয়ের আছে হলো পিএসসি ক্লার্কশিপ মেন্স আছে। আচ্ছা, আর মিসলেনিয়াস প্লাস স্টেট আছে। বাহ, অনেকগুলো আছে। আচ্ছা, কেপিএসআই আছে, একটা হয়েই যাবে, চাপ নেই। আচ্ছা, সুদীপ চ্যাটার্জির ফুড এসআই আছে, সুদীপ চ্যাটার্জির। এই যে সামনে এনটিপিসি কতজনের কার আছে? সামনে এনটিপিসি পরীক্ষা, সামনে এনটিপিসি গ্র্যাজুয়েট লেভেল পরীক্ষা কার আছে? এনটিপিসি গ্র্যাজুয়েট লেভেলের পরীক্ষা কার আছে? আচ্ছা, শান্তনু আছে, প্রতুল আছে, ক্লার্কশিপ সুদীপের আছে, শুভদীপ চ্যাটার্জির আছে, ক্লার্কশিপ মিসলেনিয়াস আছে, ক্লার্কশিপ আর মিসলেনিয়াস। সাদ্দাম হোসেন কি বলছে? দিদি ভিডিও আসে না কেন? দিদি ভিডিও আসে না কেন বুঝলাম না। সাদ্দাম হোসেন কি বলতে চাইছে? দিদি ভিডিও আসে না মানে? প্রশান্ত সাহা বলছে ফুড এসআইতে যেটা শুনলাম পিএসসি থেকে নর্মালাইজ হবে যদি কোর্ট কেসে উঠে যায়। ফুড এসআইতে যেটা শুনলাম পিএসসি থেকে নর্মালাইজ হবে যদি কোর্ট কেস উঠে যায়। প্রশান্ত সাহা, দেখুন এই বিষয়টা আমার কাছে ক্লিয়ারলি জানা নেই যে অ্যাকচুয়ালি কি হবে নর্মালাইজেশন হবে কি না, কারণ আমি ফুড এসআই যাকেই শুনছি সেই বলছে 80+, 90+, এখন কি হবে জানি না। নর্মালাইজেশন হলেও হতে পারে, যদি সেরকম তো দেখা গেলো যে একই নম্বর বহু ছেলেমেয়েরা পেয়েছে, সেক্ষেত্রে তখন তো নর্মালাইজেশন সিস্টেম করতেই হবে। অনেকগুলো শিফট হয়েছিল, নর্মালাইজেশন হলেও হতে পারে, যে শিফটে পরীক্ষা হার্ড হয়েছে। দেখা যাক কী হয়, সময় বলে দেবে। আচ্ছা, অরুণ বাগেল বলছে পুরো প্যানেল বাতিল কখন হবে? আচ্ছা, অরুণ বাগেল হলো পুরো প্যানেল বাতিলের অপেক্ষায় আছে। পুরো প্যানেল বাতিল কখন হবে সেটা তো আমাদের অপেক্ষা করতে হবে, কি হয় কি না হয়। রফিক আলম বলছে দাদা আজকের রায় কি হতে পারে অ্যাট দ্য এন্ড অফ শুনানি? আমার মনে হয় না আজকে ফাইনাল জাজমেন্ট আসবে, এটা আমার ব্যক্তিগত মত। তো তারপরেও এখন দেখা যাক, কিছু তো একটা ভালো পর্যবেক্ষণ আসবে। ও আচ্ছা, সাদ্দাম হোসেন বলছে কোর্টের রুমের ভিডিও আসছে না কেন দাদা? আচ্ছা, আসবে, এখনই আসবে। অ্যাকচুয়ালি যখনই একটা শেষ হয় পরের নেক্সট এরকম একটু সময় নেই, ঠিক আছে? একটু আগে হচ্ছিল, তো আসবে, চিন্তা নেই। শুভদীপ বলছে দাদা ফুড এসআই অনেক পাস করবে। হ্যাঁ, ফুড এসআই তো অনেক পাস করবে সেটা তো জানি, কিন্তু অ্যাকচুয়ালি ভ্যাকান্সি তো খুব কম। ফুড এসআই ভালোই দিয়েছি। আচ্ছা, লিখতে গেছো 84+ পাবো। যাদের ফুড এসআইতে 80+ আছে, মানে 85+ আছে, তারাই চান্স পাবে। তাছাড়া তার নিচে আর চান্স পাওয়া কঠিন, কারণ যেভাবে যা হয়েছে, যেটুকু যা গল্প পেয়েছি। আচ্ছা, প্রীতম বলছে দাদা 22 স্টেটদের ইন্টারভিউ কি হবে ভোটের আগে? কি মনে হচ্ছে আপনার? 22 স্টেটের ইন্টারভিউ ওবিসি মামলাটা মিটে গেলে পরে অবশ্যই হবে। আবারও বলছি, ওবিসি মামলাটা মিটে গেলে অবশ্যই হবে। গল্পেরটা বলছে আপার প্রাইমারিতে কি টেট বাদে সাবজেক্ট হবে কি? টেট বাদে সাবজেক্ট হবে বলতে, টেট বলতে আপনার যারা সায়েন্সের স্টুডেন্ট আছে তাদের ম্যাথ থাকবে, আর হচ্ছে আপনার সায়েন্সের পার্টটা থাকবে, বিজ্ঞানের পার্টটা থাকবে। আর যারা আর্টসের স্টুডেন্ট আছে তাদের জন্য 60 নম্বরের, মানে ওটা 60 নম্বরের থাকে, ঠিক আছে? আর যারা আপনার আর্টসের স্টুডেন্ট থাকবে তাদের জন্য আপনার ইতিহাস ভূগোল থেকে, আর আপনার এই কনস্টিটিউশন থেকে প্রশ্ন থাকবে 60 নম্বর, মানে যাকে আমরা বলি সোশ্যাল সায়েন্স 60 নম্বর যারা আর্টসের স্টুডেন্ট। আচ্ছা, সাদ্দাম হোসেন বলছে প্যানেল বাতিল না হোক, পিটিশনাররা চাকরি পাক। আচ্ছা, আপনাদের সামনে আরও একটা মজার বিষয় রয়েছে, যে এরপরে 26,000-এর আপনাদের শুনানি হবে তখন বিষয়টা আরও হবে। আচ্ছা, কি প্রশান্ত সাহা বলছে এটা মিটিংয়ে হয়েছিল মিঠুন দা, কারণ থার্ডের বেসিস করে 6th শিফটের কোশ্চেনে অনেক ডিফিকাল্ট ছিল। হ্যাঁ, এটা আমি জানি, আমি অ্যানালাইসিস করেছিলাম, আমি তার লাইভও করেছিলাম। আমি খুব ভালো করেই জানি যে আপনার ফুড এসআইয়ের কোশ্চেন ফার্স্ট শিফটের থেকে, সেকেন্ড শিফটের থেকে থার্ড শিফট, 6 শিফট শেষের দিকে কোশ্চেন খুব টাফ হয়েছিল, তো সেখানে দাঁড়িয়ে নর্মালাইজ হতে পারে, এটা আমি একদম করছি না। তারপরে কি ধনঞ্জয় বলছে কতগুলো ক্যান গৃহীত হয়েছে এই মুহূর্তে আমার কাছে সঠিক আপডেটটা নেই, এই জন্য জানাতে পারছি না, আমি আন্তরিকভাবে দুঃখিত। এসকে আনারুল বলছে প্যারা টিচাররা আলাদা নোটিফিকেশনে নিয়োগ চলছে। গল্পটা বলছে টেট প্লাস সাবজেক্ট। আমি আপনাদের এই আপার প্রাইমারির যে সিলেবাস, আপনাকে কি পড়তে হবে কি না পড়তে হবে, কোন বই পড়তে হবে, A to Z আমি কিন্তু সিলেবাস একদম সুন্দর করে অধ্যায় ধরে ধরে দিয়ে দিয়েছি। এই একটু 2 ঘন্টা আগেই আমি আপনাদের সেই ভিডিও দিয়েছি, সেই একদম লাইভ ক্লাসে ছিলাম। কোন বই পড়তে হবে, কোন বইগুলো বিগত বছরের শিক্ষকরা পড়ে উত্তীর্ণ হয়েছে, সেই সব বই তাদের সঙ্গে আমরা কিন্তু আলোচনা করে সেই বইগুলো আপনাদের সামনে তুলে ধরেছি। সেগুলো দেখবেন। পুলিশের চাকরি কি খুব কঠিন দাদা? পুলিশের চাকরি না, পুলিশের চাকরি দেখুন, আমি আপনাদের বলি, আমার অনেক বন্ধুরা আছে, যে কেউ পুলিশে কনস্টেবলে আছে, কেউ এসআইতে আছে। আমি আপনাদের বলি, পুলিশের চাকরি কঠিন কিছুই না। পুলিশের চাকরিতে ছুটিটা কম থাকে, পুলিশে কোনো কঠিন কাজ কিছু থাকে না। আবার বলে দিচ্ছি, যারা পুলিশ অ্যাসপিরিয়েন্ট, যা পুলিশ হওয়ার ইচ্ছা বা স্বপ্ন দেখছেন, তাদের বলে দিই, পুলিশের চাকরিতে কঠিন কোনো কাজ থাকে না, ভারী কোনো কাজ থাকে না। পুলিশের কাজই হলো, আমি আপনাদের একদম যেগুলো বলছি পুলিশ নিয়ে, এটা কিন্তু একদম অথেন্টিক্যাল বলতে পারেন, কারণ আমার অনেক ফ্রেন্ড সার্কেলে কেউ পুলিশের এসআই আছে, কেউ কনস্টেবল আছে, তো তারা বলে তাদের সঙ্গে কথা হয়েছে, পুলিশে কোনো কঠিন কাজ ভারী কাজ বলে কিছু নেই। পুলিশের কাজ হলো শুধু বসে থাকা, দাঁড়িয়ে থাকা, ঠিক আছে, কোনো কাজ নেই পুলিশের, শুধুমাত্র কি আপনার ছুটিটা কম পাবেন, এটা হলো ছুটিটা কম পাবেন, যখন তখন ডিউটি থাকে এটাই, কিন্তু তার মধ্যে ছুটিও থাকে, কপাল ভালো হলে ভালো জায়গায় ডিউটি হয়ে গেলে সেরকম অনেক অনেক সিস্টেম থাকে। হ্যাঁ, তাই বলে যে পুলিশে কঠিন কাজ, এটা ভুল কথা। পুলিশে কঠিন কাজ না, ডিউটিটা একটু থাকে, অন্য চাকরি থেকে ডিউটিটা একটু বেশি থাকে, এই ছুটিটা মনের মতো নেওয়া যায় না, এছাড়া কঠিন কাজ বলে কিছু নেই পুলিশে। দাঁড়িয়ে থাকা, বসে থাকা, এই হলো কাজ পুলিশের। বললাম ওবিসি না মিটলে কি তাহলে কিছুই হবে না দাদা? হ্যাঁ, ওবিসি না মিটলে রফিক আলম, ওবিসি না মিটলে ভাই কিছু হওয়া কঠিন, ওবিসি না মিটলে কিছু করবে না, ওবিসি না মিটলে কিছু করবে না, পরিষ্কার, এটা বার্তা। ওবিসি মানে এটা রাজ্য সরকার বলেই দিয়েছে, ওবিসি না মেটা পর্যন্ত আমরা কিছু করতে পারবো না, কিন্তু আমরা কিন্তু সুপ্রিম কোর্ট বা হাইকোর্ট বলুন বহুবার বলেছি, সেখান থেকে কোনো বাধা নেই, তারা সাবজেক্ট টু আউটকাম দিয়ে কিন্তু করতেই পারতো, কিন্তু করবে না। আচ্ছা, আনারুল বলছে সিঙ্গেল বেঞ্চে সব গুলিয়ে ফেলেছেন। ডিএলএড সার্টিফিকেট কিনবো কি করে বলো? ডিএলএড সার্টিফিকেট, দেখুন ভালো কথা, আপনারা এটা পরিষ্কার, এটা তো রাজ্য সরকারের ঘোষণা না, সুপ্রিম কোর্ট থেকে বলেছে, সুপ্রিম কোর্ট থেকে আপনার সুপ্রিম কোর্ট বলছি, কোর্ট থেকে জানিয়েছে যে টেট নিতে হবে, তো এটা তো আপনার কোর্টের রায়কে তো আর অবমাননা করতে পারবে না, পরীক্ষা নিতেই হবে, তো পরীক্ষা যেহেতু নিতে হয় সেহেতু আর কারা বসতে পারবে আমি এটা কিন্তু বলেছি, যাদের ডিএলএড বিএলএড থাকবে রানিং কোর্স তারাও কিন্তু বসতে পারবে। আবারও বলে দিচ্ছি, যদি আপনারা কেউ ডিএলএড বিএলএড অ্যাডমিশন নিতে চান, আমার নিজস্ব কলেজ আছে, সেখানে একদম কম খরচে আপনার অ্যাডমিশন নিতে পারবেন, সেই সুযোগ থাকবে। আপনারা অবশ্যই আমার হোয়াটসঅ্যাপ নম্বরে হোয়াটসঅ্যাপ করতে পারবেন, এখনই সময় আছে, কারণ এখন কিন্তু আবার বাজারে দাম বেড়ে যাবে, কারণ ভালো করেই জানেন, সবাই জানে, বুঝবে যে এখন তো একবার এই মনে আছে 22 স্টেটের কথা, সেই কী আকারে দাম বেড়েছিল ডিএলএডের, ঠিক তেমনি কিন্তু এখন বিএড ডিএড দুটোরই দাম বেড়ে যাবে, কারণ আপনি বিএড ডিএড যেটাই থাকুন না কেন, আপনি যদি থাকেন তাহলে কিন্তু আপনি বসতে পারবেন, তো বিরাট অপরচুনিটি থাকবে এখানে, সবাই চেষ্টা করবে, ভালো অপরচুনিটি থাকবে, সবাই মানে থাকলেই বসতে পারবেন। কি বলছে শুভদীপ বলছে, দাদা আপার প্রাইমারিতে কি 40K ভ্যাকান্সি শুনছি, এটা কি সত্যি? আপার প্রাইমারিতে 40,000 ভ্যাকান্সি, 40,000 ভ্যাকান্সি, দেখুন ভ্যাকান্সি তো অবশ্যই 40-এর বেশি আছে, কিন্তু ভ্যাকান্সি কতটা দেবে সেটা আমি আবারও বলি, আমাদের রাজ্যে আপনি আপনার বাড়ির আশেপাশে প্রত্যেকটা স্কুলে যান, গিয়ে দেখুন, হেড স্যারের সঙ্গে কথা বলুন, দেখবেন কোনো স্কুলে 3 জন 4 জন 5 জন 6 জন 7 জন নিয়ে পুরো স্কুলটা চলছে, তো প্রচুর টিচার ভ্যাকান্সি ফাঁকা আছে, সরকার চাইলে 50-40,000 কেন 50,000-এর নিয়োগ করাতে পারে। এখন এটা সঠিক যে 40,000 ভ্যাকান্সি দেবে এটা আমার জানা নেই সঠিক, আমি জানতে পারলে অবশ্যই জানাবো। আচ্ছা, কি পবন মাহাতো বলছে প্যানেল বাতিল হবে না 100%, আচ্ছা ভালো কথা। গল্পটা বলছে 150 স্টেটের টেট হওয়ার পর ধরেন, তারপর যারা জিওগ্রাফি পেপার শুধু দেবে কি দাদা? আরে না, এটা না, এটা আপনি একদমই ভুল ব্যাখ্যা করছেন, মানে ভুল বুঝতে পারছেন। আপনাকে টোটালে আপনাকে 150 নম্বরের মধ্যে পরীক্ষা দিতে হবে, 150 নম্বরের মধ্যে পরীক্ষা দিতে হবে টোটাল, তার মধ্যে আপনাদের চাইল্ড স্টাডিজ মানে প্যাডাগোগি নিয়ে, হ্যাঁ, তাতে থাকবে 30, বাংলায় থাকবে 30, ইংরেজি থাকবে 30, 3-30-এ 90, আর 60 নম্বর থাকবে আপনার ওই যারা আর্টসের সাবজেক্ট তারা সোশ্যাল সায়েন্স, আর আপনার যারা সায়েন্সের তাদের হচ্ছে আপনার ম্যাথ আর হচ্ছে ম্যাথ আর সায়েন্স, এই সিলেবাস, যারা সায়েন্সে তাদের 60 আর যারা আর্টসে তাদের 60, বুঝতে পারলেন? এটা হচ্ছে টোটাল সিলেবাস, তাছাড়া আলাদা করে না, একসঙ্গেই 150টা কোশ্চেন একসঙ্গেই থাকবে, কিন্তু পাকপাটে আপনারা টেট পরীক্ষা দিয়েছেন যারা ভালো করে জানবেন, এরকম বাংলার জন্য আলাদা ভাগ করা থাকবে, হ্যাঁ, A-B-C-D এরকম করে ভাগ করা থাকবে। আমি বিগত বছরের প্রশ্ন টেলিগ্রাম গ্রুপে দিয়ে রাখবো, সেখান থেকে দেখে নেবেন। কমল এডুকেশন বলছে প্যানেল বাতিল অবশ্যই হওয়া চাই, না হলে দুর্নীতি বাড়তেই থাকবে। আপনার কথা যুক্তি আছে, অবশ্যই যুক্তিসঙ্গত কথা বলেছেন যে প্যানেল বাতিল হওয়ার প্রয়োজন আছে। ডিএলএড সার্টিফিকেট কি করবে কিনবো বলো? ডিএলএড সার্টিফিকেট কেনা কি করে পসিবল, কি করে কিনবে? আপনাকে অ্যাডমিশন নিতে হবে, পরীক্ষায় বসতে হবে, পরীক্ষা দিতে হবে, ডিএলএড সার্টিফিকেট কি সে আপনি কি বলে সেই যুগে আছেন নাকি? এখন কি সম্ভব নাকি? আপনাকে কে সার্টিফিকেট দেবে? কেউ সার্টিফিকেট দিতে পারবে না, আপনাকে অ্যাডমিশন নিতেই হবে। মিঠুন দা, মিসলেনিয়াস মেন্স কবে হতে পারে? মিসলেনিয়াস মেন্স কবে হতে পারে? ওবিসি মামলাটা মিটলে পরে মিসলেনিয়াস এর মেনের পরীক্ষা, ক্লার্কশিপের মেন পরীক্ষাগুলো হবে। ভোটের আগেই দেখবেন হবে এই পরীক্ষাগুলো, অবশ্যই এইটুকু বলছি, ভোটের আগে এই পরীক্ষাগুলো হবে ওবিসি মামলাটা মিটে গেলে। অরুণ কি বলছে? অরুণ বাবু বলছে পুরো প্যানেল বাতিল হয়ে গেছে। দাদা আপনি ঘোষণা করেছেন পুরো প্যানেল বাতিল হয়ে গেছে। আমি জানি না ভাই এখনো পুরো প্যানেল বাতিল হয়েছে কিনা, খবর আমার কাছে আসেনি। বিনোদ কুমার, পুলিশ কোয়ালিফিকেশন মাস্ট বি ইউজি। পুলিশ কোয়ালিফিকেশন মাস্ট বি ইউজি। আচ্ছা, কি শান্তনু কাকার বলছে পিএসসি মিসলেনিয়াস থেকে ডাব্লিউবিসিএস হওয়া যায়। মিসলেনিয়াস অফিসার 10 বছর কাজ করার পর 10 বছর পর প্রমোশনের মাধ্যমে আপনি ওই ডাব্লিউবিসিএস এর ডি গ্রুপ পোস্টে আসতে পারেন, ডিসিতে আসতে পারবেন, ডিসি গ্রুপ পর্যন্ত আসা যায়, এটুকু আমি জানি, প্রমোশনের মাধ্যমে আর কি। আচ্ছা, গল্পটা বলছে থ্যাংক ইউ দাদা, থ্যাংক ইউ সো মাচ। অনিমেষ ঘোষ বলছে দাদা 22 প্রাইমারি টেটদের নিয়োগ হবে। 22 প্রাইমারি টেটদের নিয়োগ হবে। ওবিসি মামলাটা মিটে যাবে বলে মনে হয় তাড়াতাড়ি। আচ্ছা, প্রশ্ন করছেন সবই। হ্যাঁ দেখুন, 22 টেট সরকারের হাতে স্বচ্ছ ভোটের আগে যাওয়ার মতো একটা রিক্রুটমেন্টই আছে, যেটা 22 টেট। তো 22 টেটের রিক্রুটমেন্টটা আশা রাখছি ভোটের আপনার নির্বাচনের আগে অবশ্যই মেটাবে, এবং ওবিসি মামলা মিটলে আপনাদের ইন্টারভিউ নোটিশ আসবে। বিনোদ কুমার বিএড বলছে বিএড করতে চাই। হ্যাঁ, বিএড করতে চাইলে আমাদের হোয়াটসঅ্যাপ নম্বর দেওয়া আছে, হোয়াটসঅ্যাপ নম্বরে অবশ্যই যোগাযোগ করুন। কারণ যত লেট করবেন, কারণ যত সময় আসবে তত কিন্তু আপনার রেট বাড়বে। এখন আপনাদের এটা বাস্তব কথা, এটা কোনো ইসের কথা না, আপনারা ভালো করে জানেন যে 22 টেট যে কী পরিমাণে অ্যাপিয়ারিং হিসাবে বসেছিল। যারা নতুন অ্যাডমিশন নেবে তারাও কিন্তু বসতে পারবে। তো সেখানে দাঁড়িয়ে কিন্তু কম্পিটিশন হু করে বাড়তে থাকবে। আর পরে এখন ভাববেন না দেরি করি, পরে অ্যাডমিশন নিলে কিন্তু রেট বেড়ে যাবে। এই জন্য যদি অ্যাডমিশন হওয়ার ইচ্ছা থাকে অবশ্যই যোগাযোগ রাখতে পারেন। সেলিম আনসারি বলছে 26-এর রিভিউ পিটিশনের ব্যাপারে কোনো আপডেট আছে কি? রিভিউ পিটিশনের ব্যাপারে আপডেট না, এখনো পর্যন্ত আপডেট নেই। উঠলে পরে তো অবশ্যই আমরা লাইভে থাকবো, তা নিয়ে কোনো চিন্তা নেই। দাদা 16 আপার টেট পাস করেছিলাম, ডিএলএড করতে পারিনি। 16 সালের আপার টেট পাস করেছিলেন, ডিএলএড করতে পারেননি। হ্যাঁ, ডিএলএড তো করতে হবে, ডিএলএডটা করুন, ডিএলএড অ্যাডমিশন নিয়ে নিন। ডিএলএড বা বিএড বা আইটিআই যে কোনো অ্যাডমিশন নিতে চাইলে পশ্চিমবঙ্গের যে কোনো প্রতিষ্ঠানের থেকে আমরা কিন্তু সমস্ত রকম সুযোগ সুবিধা দিই, এবং সেভাবে করে আমরা সহযোগিতা করব, চেষ্টা করব আমি ব্যক্তিগতভাবে। যোগাযোগ করতে পারেন, কোনো ব্যাপার না। ডিএড বিএড এবং আইটিআই যে কোনো প্রফেশনাল ডিগ্রি বা ডিপ্লোমা বলুন, আপনার নার্সিং বলুন, আপনার হ্যাঁ এই ডিগ্রিগুলো যদি করতে চান তাহলে অবশ্যই যোগাযোগ করতে পারেন। বা ফার্মেসিটি করতে চাইলেও যোগাযোগ করতে পারেন। আচ্ছা, সারা প্যান বলছে কখন শুরু হবে? অবশ্যই এখনই শুরু হবে। এনওএস ডিএলএড করব না, এনওএস থেকে আর ডিএলএড করবেন না, আমি ওইটুকু অনুরোধ করবো। এনওএস থেকে আর করার দরকার নেই। এটা আমার ব্যক্তিগত মত, আপনার ইচ্ছা করতে পারেন, কিন্তু আমি ব্যক্তিগতভাবে বলবো না করাই ভালো। প্রশান্ত বলছে একটু মান্থসটা বলে দিলে মিসলেনিয়াস মেন্সটা ভালো হতো। দেখুন, আমি আপনাকে একটা আইডিয়া দিতে পারি, ধারণা দিতে পারি, তার বেশি নয়। আমি যেটুকু পর্যবেক্ষণ করে, যেটুকু আমার ক্ষুদ্র জ্ঞানে যেটুকু বলে, আপনার জুলাই মাসে আবার ওবিসি মামলাটা উঠবে, তো জুলাই মাসে যদি ওঠে, জুলাই আগস্ট সেপ্টেম্বরে যদি ধরুন আগস্ট মানে ধরে নিন যদি আগস্ট সেপ্টেম্বরে আশা করি মিটে যাবে, আগস্ট সেপ্টেম্বরের মধ্যে মিটে গেলে পরে নভেম্বর ডিসেম্বরের দিকে পরীক্ষা হবে, একটু সেইভাবে করে টার্গেট করে এগিয়ে চলুন। সাদ্দাম হোসেন, আদেও কি আজকে শুনানি হবে? হ্যাঁ, শুনানি তো হবে। রীতি বাংলা বলছে এই প্যানেলে পিটিশনারদের সঙ্গে সমঝোতা হোক। একদম। কখন শুরু হবে? এখনই শুরু হবে। গৌতম বিশ্বাস বলছে 2022 বিএড দিয়ে পাশ করেছিলাম। আচ্ছা, এটা আপনার বক্তব্য, ভালো। বিএড দিয়ে 22 স্টেট, বুঝতে পারছি। সঞ্জীব চন্দ্র বর্মন বলছে ওএমআর কেসটা কবে উঠবে? ওএমআর কেসটা আপাতত আপডেট নেই, আপডেট আসলে অবশ্যই জানিয়ে দেবো। আমাদের চ্যানেল ফলো করে রাখুন। আমি অবশ্যই প্রত্যেকটা আপডেট ভিডিও না করতে পারলেও কমিউনিটি পোস্ট করে রাখি ইউটিউবেই, কমিউনিটি পোস্টে দেখবেন সবসময় আপডেট দিতে থাকি। আচ্ছা, শুভদীপ চ্যাটার্জি বলে দাদা ওবিসি মামলা মিটলেই আমরা নববর্ষ পালন করব কিন্তু। একদম। লাভ ইউ বলছে আপার প্রাইমারি পাস করেছিলাম, সেটা ইন ফিউচারে কাজে লাগবে কি? আপার প্রাইমারি পাস করেছিলাম, সেটা ইন ফিউচারে কাজে লাগবে কি? আপার প্রাইমারি লাইফ টাইম সার্টিফিকেট, আপার প্রাইমারি যদি লাইফ টাইম সার্টিফিকেট হয়ে থাকে অবশ্যই কাজে লাগাতে পারবেন যদি বিএড ডিএড করা থাকে। আর আপার প্রাইমারি লাইফ টাইম সার্টিফিকেট না হলে সেটা কাজে লাগাতে পারবেন না। পিয়ালি প্রামাণিক বলছে 2022 প্যানেল কবে নাগাদ দিতে পারে? 2022 প্যানেল কবে নাগাদ দিতে পারে? 2022 প্যানেল আপনাকে অপেক্ষা করতে হবে বেশ কিছুদিন অপেক্ষা করতে হবে। তবে আমি একান্তই ব্যক্তিগত মত বলছি, হ্যাঁ, সামনে আপনার বিধানসভা ভোট রয়েছে 26-এর। ভোটের আগে অনেক খেলা হবে, অনেক নিয়োগ হবে, অনেক কিছু হবে। শুধু এটুকুই বললাম, আগেও বলেছি, আমার কথা নিয়ে অনেকেই খিল্লি করেছিলেন, মনে করে দেখুন যারা খিল্লি করেছেন তারাও হয়তো এই চ্যানেলে আছেন এখন। আমি বলেছিলাম যে নতুন করে টেট 200%, 100%, 1000% এরকমভাবেই বলেছিলাম যে নতুন করে টেট হবেই হবে। সেটা কোর্টের মাধ্যম, কোর্ট জোর করে করাচ্ছে, আর রাজ্য সরকার ইচ্ছাকৃতভাবেই হোক, আমি বলেছিলাম ভোটের আগে টেট তো হবেই, সেটা হচ্ছে। আবার আমি এটাও বলেছিলাম যে এই 22 স্টেটের ইন্টারভিউ হবে, নিয়োগ হবে। আবার আমি এটাও বলেছিলাম যে নতুন করে টেট পরীক্ষাও নেওয়া হবে। তাহলে বলবেন এখন দাদা এত কিছু কি করে হবে? ভোটের আগে দেখবেন সব হবে। আর পুলিশের নিয়োগ তো হবেই হবে, শুধু এটুকু বললাম। আচ্ছা, অনেকের মনে হতে পারে যে না সব কথায় ভুল, কিন্তু একটা একটা করে আস্তে আস্তে সব মিলবে। গৌতম বিশ্বাস বলছে 2022 স্টেট ডিএড দিয়ে শুরু করেছিলাম, 22 স্টেট ডিএড দিয়ে শুরু করেছিলাম, পরে 23-25-এ ভুল লিখছেন, আমি বুঝতে পারছি আপনি বলতে চাইছেন 2022 স্টেট বিএড দিয়ে শুরু করেছিলেন, পরে 23-25 ডিএলএড করেছি, 23-এ অ্যান্সার কি অনুযায়ী 2023-এও পাশ করেছি। তাহলে আমি কি আগামী ইন্টারভিউ হলে কি বসতে পারবো? দেখুন, যদি 22-এর বিএড দিয়ে পাশ করে থাকেন সেখানে বসতে না পারলেও 23-25 সেশনে যে আপনি 23-25 সেশনে আপনি যেটা পাশ করেছেন 23-এরটাই, সেটাই কমপ্লিট হয়ে আপনার ডিএলএড কমপ্লিট হলে অবশ্যই বসতে পারবেন। সঞ্জীব চন্দ্র বর্মন বলছে এসএসসিতে কি নতুনরা বসতে পারবে? আচ্ছা, 26,000 যেটা বলছেন আমি বুঝতে পারছি, ওটা বসতে পারবে কি না সম্পূর্ণ এভরিথিং ডিপেন্ড অন বোর্ড এবং আমাদের মাননীয় মুখ্যমন্ত্রী মামাটি মানুষের সরকার। তিনিই জানেন, দরদিনী, মায়াময়ী, মমতাময়ী, তিনিই জানেন যে অ্যাকচুয়ালি বসতে দেবেন কি না। ঠিক আছে, তো সুপ্রিম কোর্টে জাজমেন্ট অনুসারে বসতে দেওয়া কোনো বাধা নেই, কিন্তু এখন দেখা যাক সেখানে বসতে দেয় কিনা, কি নোটিফিকেশান আসে তার উপর ডিপেন্ড করছে যে নতুনদের বসতে দেবে কিনা। এই নিয়ে অনেক সংশয় রয়েছে। আমাদের মাননীয় মুখ্যমন্ত্রীর প্রসঙ্গে আসতে গেলে তিনি বলেছিলেন যে আমরা আলাদা করে নেব। তো আমার যেটুকু মন বলে যে ওই মাননীয় মুখ্যমন্ত্রী কথায় থাকবেন, এখানে শুধু ওই পুরনটাই বসবে, নতুনদের বসতে দেবে না। শুনানি কি স্টার্ট হচ্ছে না? এখন শুনানি স্টার্ট হয়নি, শুনানি হলে তো এখানে দেখতে পারবেন। কি বলছে দয়াল মাহাতো বলছে বিএড থাকলে বিএড থাকলে টেটে বসতে পারবো কি? বিএড থাকলে আপার টেটে বসতে পারবেন, আপার টেট, যেটাই যে আপনার বের হচ্ছে, যেটা আপনার কোর্টের নির্দেশে যে টেটের পরীক্ষাটা হবে, মানে ক্লাস 6 to 8 এই পরীক্ষাটায় বসতে পারবেন, আপার টেট। ডিএড থাকলেও বসতে পারবেন, বিএড থাকলেও বসতে পারবেন, তা নিয়ে কোনো চিন্তার কিছু নেই। ডিএড থাকলেও বসতে পারবেন, বিএড থাকলেও বসতে পারবেন। এ নিয়ে চিন্তার কিছু নেই। কি পারলে কোথায় যাওয়া যাবে? বুঝতে পারলেন ব্যাপারটা? প্রশান্ত সাহা বলছে, দাদা তোমাকে একটা সত্য কথা বলে দিই, সেটা হচ্ছে গভর্নমেন্ট ভোটের আগে অনলি যে 26,000 বাতিল তাদের রেজাল্ট বার করে নিয়োগ দিয়ে দেবে, আর পুলিশের অনলি কনস্টেবল আর কেপি নিয়োগ করে ক্লোজ করবে, এই দুটো এক্সাম কন্ডাক্ট হবে। হ্যাঁ, কিছুটা একমত, কিছুটা যেটা বলেছে প্রশান্ত সাহার কথা যেটা বলেছে কিছুটা একমত। হ্যাঁ, এটা ঠিকই বলেছেন যে সরকার তার পূর্বের যেটা করেছে, পূর্বে যা মানে আমাদের মাননীয় মুখ্যমন্ত্রী তিনি কিন্তু পরিষ্কার বলেছেন যে আমরা কিন্তু এই চাকরি খাইনি, এই চাকরি খাওয়ার পিছনে কিন্তু আমরা নয়, তারা কিন্তু পরিষ্কার বলেছেন, মাননীয় মুখ্যমন্ত্রী পরিষ্কারভাবে বলেছেন যে এই চাকরি কিন্তু আমরা মানে বাদ করিনি, আমরা চাকরি ছাড়িয়ে দিইনি আর কি, মানে ইয়ে করিনি, এই হলো বিষয়। আচ্ছা, আপনার একটা ভিডিও দেখেছিলেন, ওই সেই আপনার রানাঘাটের অস্মিকা নাম করে একটা বাচ্চা মেয়ের জন্য টাকা তুলছিল, ওই 16 কোটি টাকার একটা ইঞ্জেকশন লাগবে, অস্মিকা বিরল রোগে আক্রান্ত। আজ দেখলাম খবরে দেখাচ্ছে যে ওই 16 কোটি টাকা নাকি উঠেছে, সে এবার বিরল রোগ থেকে মুক্তি পাবে। আদৌ কতটা সত্যি কতটা মিথ্যা জানি না, দেখছিলাম যে ওই 16 কোটি টাকা নাকি উঠে গেছে। আচ্ছা, ডিএর ব্যাপারটা জানেন তো, পশ্চিমবঙ্গ সরকার কর্মচারীদের মাত্র 18% মহার্ঘ ভাতা মানে ডিএ দেয়, আর সেখানে আমাদের কেন্দ্র কিন্তু 55% ডিএ দেয়। হ্যাঁ, কিন্তু প্রাথমিক অনুমান অনুযায়ী রাজ্য সরকার কর্মচারীদের 25% মহার্ঘ ভাতা বকেয়া অবিলম্বে পরিশোধের জন্য রাজ্যের কোষাগার থেকে প্রায় 12,000 কোটি টাকা বা তার কিছু কম অর্থ তৎক্ষণিক বেরিয়ে যাবে, আর যদি পথে বসে যাবে। দেখুন কি বলছে।
ফরেন ডেলিগেশনে তৃণমূলের কেউ যাচ্ছে না, এটা ব্যাপার নয়। ব্যাপারটা যেটা হয়েছে, let us very clear that nowadays the system is they don't inform the mother party, they only inform the parliamentary party, but parliamentary party only works for the parliamentary session, but they cannot take a policy decision. So no request came to us. If the request come to us, then of course we can consider. We are totally in favor of the country. I told you earlier also, in external affairs issue, we always used to support the central government policy. If anything is special, then we will think of, but not now. At present, we are supporting the central government views and action. They cannot decide the members' name from their own. It is not their choice. It is a choice of the party. If
কিন্তু এই চাকরি খায়নি।
পূজা কি বলছে? পূজা বলছে দাদা আমার ডিএলএড কমপ্লিট হয়ে গেছে 21-23 সেশনে, বাট আমি এখন ওপেন থেকে, আচ্ছা তোমার ডিএলএড কমপ্লিট হয়ে গেছে 21-23 সেশনে, গুড, বাট আমি এখন ওপেন থেকে সেকেন্ড ইয়ারে গ্র্যাজুয়েশন করছি, ওপেন থেকে গ্র্যাজুয়েশন করছি, বেশ। দাদা আমি কি আপার প্রাইমারিতে বসতে পারবো? গ্র্যাজুয়েশন কমপ্লিট হতে হবে, গ্র্যাজুয়েশন কমপ্লিট না হলে তো বসতে পারবেন না। আপনার গ্র্যাজুয়েশন পূজাকে বলছি, আপনার গ্র্যাজুয়েশন কমপ্লিট থাকতে হবে। তো চলুন, হিয়ারিং শুরু হয়েছে, হিয়ারিং শেষ হলে আবার আপনার প্রশ্ন উত্তর দেবো। অনিমেষ, আচ্ছা হিয়ারিং শুরু হচ্ছে, তো আমি এই মুহূর্তে আর কথা বলছি না, আপনারা একটু হিয়ারিংটা দেখে নিন, তারপরে সব প্রশ্ন উত্তর দেবো। হ্যাঁ, থাকবেন, লাইভে থাকবেন, পাশে থাকবেন, কোনো প্রশ্ন থাকলে হোয়াটসঅ্যাপ করতে পারেন, কথা বলবো।
Yes. Yes, Mr.
But on the last occasion, I was addressing the court. But I had placed, my lord, the judgment under appeal. I have placed, my lord, portions of the writ petition.
And the backdrop in which the conclusion was adopted.
শুরু হয়েছে, হ্যাঁ শুরু হয়েছে।
Now, my lord, my first point would be
দয়া করে একটু শেয়ার করবেন আর সাবস্ক্রাইব
that
করবেন।
in the backdrop of the case pleaded and the made,
Yes.
my lord, whether, my lord, this kind of an order could have been passed. But I presume for argument's sake that there has been some corruption. I don't agree to that because the word corruption has to be understood first. And then whether there was any corruption or not, that would come later on. But be that as it may, whatever are the findings of the learned judge, assuming them to be correct, but whether, my lord, this direction could have been passed. Now, what is the direction? Please have a look to the about 2 paragraphs of the judgment, my lord, at page.
611.
It starts from 611.
You download. Which volume you are referring to?
My lord, it would be in the 3rd volume.
611 you left us on that day.
611 is the starting page.
Yes.
Please take paragraph 21 at page 624.
Yes.
In such circumstances, I allow the writ petition, the appointment of all 36,000 more or less candidates who were untrained at the time of recruitment in 2016 recruitment process conducted by the board in the post of primary teachers are cancelled for various reasons as have been elaborated above. The reasons will I'll take you one by one later on. But this is the ultimate direction. Please have a look to, my lord, the writ petition now. It starts, the relevant portion your lordship would find word at page 36 in the first paper book. Well, the lordships are aware of the facts by now. Well, the writ petitioners The writ petitioners, my lord, are untrained candidates. They are unsuccessful candidates. They are claiming parity with those who have been appointed, those untrained who have been appointed. And therefore, the prayer is that pass a direction or a mandamus to appoint us. Now, please have a look to my lord. For example, paragraph 11 at page 39, 3 or 4 paragraphs, because I placed it in its entirety. Yes, in its entirety. So on this point, the relevant paragraphs I'll just place.
Yes.
Paragraph 11 says, your petitioner states that on so-and-so date, notices were published for recruitment as assistant teacher in primary schools from TET 2014. The board has appointed non-trained candidates after 2016. Even and intentionally ignored the petitioners by giving excuse of notification dated 9th of April 2015. Thousands of non-trained students were appointed and the petitioners, though similarly placed, very important, petitioners, though similarly placed, were ignored. If it is the stand of the board that no non-trained candidates can be appointed, then all the appointments of non-trained candidates made after March 2016 are bad in law. The relaxation given by NCT, etc., to applicable to all TET 2014 candidates who qualified for examination. Or in other words, Millard, they are claiming parity with those who have been appointed. Yes. But the case made out is, as your lordship would find out from all the paragraphs, that these people have been discriminated, or the petitioners have been discriminated, qua those who have been appointed. Now please take another paragraph, which is paragraph 20 at page 43.
Yes.
Your petitioner states that your petitioners are praying for equality before law and equal protection of the law. Huge number of non-trained candidates were appointed by the board, and when the petitioners are seeking the same benefit, the board is saying NCT guidelines is against them. The NCT guidelines was there since 2016, and if TET 2014 qualified non-trained candidates can be appointed in 2017, then there should be no bar in appointing the present petitioners.
Yes.
Then para 21. Last sentence in para 21, I don't think the entire paragraph is required, but last sentence, para 21. But here the board has done complete injustice to the petitioners. Now this is the fulcrum of the grievance.
Yes.
Now please have a look to the prayers at page 47. I placed it on the last occasion also. Please have a look to it, prayer B triple I at page 47.
Yes.
To direct the authorities to treat the petitioners equally with the non-trained candidates who have been recruited by the board after expiry of relaxation given by MHRD on 9/4/2015. Then Roman 4, to recruit the petitioners by giving them the same benefit by which the other non-trained candidates were recruited by the board by following the rules dated 2nd March 2016 and appointment notification dated 26/9/2016. 5 is to direct the authorities to publish merit list by maintaining full transparency regarding TET 2014, then to protect all documents, etc. No prayer for cancellation of anybody's appointment.
Yes.
Therefore, my lord, on this issue, there are two facets. The first facet is that the petitioners are claiming parity with a category of candidates who have been appointed because they fall under the non-trained category. So parity claim queer discrimination is the first facet. The second facet is applying for mandamus or praying for a mandamus that we should be appointed. Now, in this background, or in the context of this pleading and the relief sought, whether 36,000, 32,000, whatever candidates' appointment can be cancelled or not, in my very respectful submission, it cannot be done. Because reliefs are to be given in terms of the case made out and relief sought.
No, you please place paragraph 22 also.
Very well. Corruption. But I'll come to corruption.
As you are talking out the pleadings, broadly the pleadings was this.
Subject to your lordship's permission, but I would like to address your lordship on each point separately, and I'll place the relevant paragraphs square the point. But when I'll deal with the corruption issue, but I'll definitely come to paragraph 20.
Yes. On the basis of these pleadings, this order at least could not have
been made. This is the first point. Number one or two decisions on this, then I'll
yes.
I'll go to the next issue. এই জাজমেন্টগুলো ধর এখানে এসে
আমাকে দিয়ে দে এখানে
2010 বের কর 2010 সিসি পেয়েছিস 10 সিসি 234 করিস না আস্তে আস্তে গুলিয়ে ফেলবি
If you don't have it, we can use. We can get.
But I have made copies. আরেকটা কপি দে আরেকটা দে না পরেরটা সেলাই করে নি But I'm sorry, but it's not stitched, Kali, excuse me. But the first judgment on this point is reported in 20 এই পরের জাজমেন্টটা বের করে দেন খুঁজতে সময় লাগবে 2024-2 SCC 570 This is reported in 2010 volume 1 Supreme Court cases page 234 But I'll be relying on paragraphs 29 to 33 24-2 570
Yes.
29 to 33
Yes.
The approach of the High Court in granting relief not prayed for cannot be approved by this court. every petition under Article 226 of the Constitution must contain a relief clause. Whenever the petitioner is entitled to or is claiming more than one relief, he must pray for all the reliefs. Under the provisions of the Code of Civil Procedure, if the plaintiff omits, except with the leave of the court, to sue for any particular relief which he is entitled to get, he will not afterwards be allowed to sue in respect of the portion so omitted or relinquished. Though the provisions of the code are not applicable to the proceedings under Article 226 of the Constitution, the general principles made in the Civil Procedure Code will apply even to writ petitions. It is therefore incumbent on the petitioner to claim all reliefs he seeks from the court. Normally, the court will grant only those reliefs specifically prayed for by the petitioner. Though the court has very wide discretion in granting relief, the court, however, cannot, ignoring and keeping aside the norms and principles governing grant of relief, grant a relief not even prayed for by the petitioner. In Krishnapriya Ganguly, overlooking the rule relating to grant of admission to postgraduate course in medical college, the High Court, in the exercise of powers under Article 226 of the Constitution, directed the Medical Council to grant provisional admission to the petitioner. This court set aside the order passed by the High Court, observing that in his own petition in the High Court, the respondent had merely prayed for a writ, directing the state or the college to consider his case for admission. Yet the High Court went a step further and straightaway issued a mandamus directing the college to admit him to the MS course, and thus granted a relief to the respondent which he himself never prayed for and could not have prayed for. Again, in Om Prakash versus Ram Kumar, it was held a party cannot be granted a relief which is not claimed if the circumstances of the case are such that granting of such relief would result in serious prejudice to the interested party and deprive him of the valuable rights under the statute. Though a High Court has power to mold relief, this part is very important. Though the High Court has a power to mold reliefs to meet the requirement of each case, that does not mean that the draftsman of a writ petition should not apply his mind to the proper relief which should be asked for and throw the entire burden of it upon the court. Well, very frequently it is said that the court can mold the relief. But here, Milord, the Supreme Court says that you have to be careful about your drafting. You cannot expect the court to take upon itself the burden of granting the relief. Pray for the relief, make out a case, get the relief.
Yes.
What a pitch.
Next judgment.
But the next judgment is 2024, Volume 2, Supreme Court Cases, page 570, 570.
Whereas
Only one paragraph, 26. Page is so. আচ্ছা 10-11 বের করে রেখেছিস AIS 61 ক্যালকুলেটর বের করে But only one paragraph from this judgment, para 26.
yes.
I need not place, just will not note the paragraph number. It's saying the same thing. But the other judgment on this point is 2010, Volume 11, Supreme Court Cases 557. 10-11. 2010, Volume 11, Supreme Court Cases 557. We had a few paragraphs from this judgment. But at paragraph 2, the Supreme Court will not frame the issues to be answered. Paragraph 2. In these appeals, three substantial questions of law for consideration of this court are involved. They are namely, please take C. Whether the court can grant relief which had not been asked for. Formulating this question, now Supreme Court starts discussing. Please come to paragraph 30.
Yes.
In Projan and Company, this court considered the issue as to whether relief not asked for by a party could be granted, and that too without having proper pleadings. The court held it is well settled that the decision of a case cannot be based on grounds outside the pleadings of the parties, and it is the case pleaded that has to be found. Without an amendment of the plaint, the court was not entitled to grant the relief not asked for, and no prayer was ever made to amend the plaint so as to incorporate. 61 Calcutta Brigade is 61 Calcutta with the ACC online. It is well settled that the decision of I'm reading the quoted paragraph 22.
Without an amendment of the plain, court was not entitled.
Yes. Para 31 says a similar view was reiterated by this court in so and so. Observing that a party cannot be granted a relief which is not claimed. Dealing with the same issue, this court in Bharat Amrat Lalmer, this one I have placed. Then para 33, in Fertilizer Corporation, this court held that the High Court ought not to have granted reliefs to the respondents which they had not even prayed for. Para 34, in view of the above, law on the issue can be summarized that the court cannot grant a relief which has not been specifically prayed by the parties. The instant case requires to be examined in the light of the aforesaid legal principle. Therefore, my lord, here also, my lord, I am praying before this court that in view of the pleadings and the case made out, irrespective of whether the prayer has been made or not, whether this prayer could have or this relief could have been granted or not. I assume for argument's sake that the prayer is couched in such a manner that it could have been granted. Even assuming that, my lord, the case which is made out does not call for, my lord, cancellation of appointment of strangers, non-parties. Well, that is an issue I'll take later on separately.
Yes.
But there's an old judgment of our High Court of 1961. Well, it's a single bench judgment, but kindly have a look to it. AIR 1961 Calcutta, page 411. No, ওটা লেখাই আছে, ওটাও লেখা।
Yes, para.
But paragraph 27 of the report.
Yes.
Drawing the principles of Order 7, Rule 7, the court holds, it is contended that even though a restricted injunction is claimed in prayer H, the court is entitled to grant a decree for injunction in wider terms. There is a prayer for further and other reliefs. Further, Order 7, Rule 7 expressly empowers the court to grant such general or other relief as the court may think just, to the same extent as if it had been asked for. In order, however, that such a relief can be granted, the ground for granting such relief must not be inconsistent with the claimant's claim. This is very important. it is contended by Mr. Chaudhary that the plaintiff's case is that the lease was granted, etc. Therefore, the relief also should not be inconsistent. That's why I said, my lord, assuming, my lord, for argument's sake, that the relief that has been granted could be inferred from the prayers, or the prayers are couched in such a manner that such a relief is contemplated. Even, my lord, assuming this for argument's sake, then also the relief should not be inconsistent with the petitioner's claim.
Yes.
And subject to correction by my learned friends, possibly the writ petitioners are not aggrieved by this order. Possibly they have not preferred an appeal. Possibly subject to correction. আচ্ছা এইটা না করে না 2008 চারটা বের কর 8 4
সিলেকশন হবে পরে কিছু বললো না অ্যাডমিনিস্ট্রেশন থেকে আদার্স প্রতিরোধী আরিয়া ঠিক আছে Yes.
বুঝলি 8 4 এটা ওটা গুলো না গিয়ার ওয়াইজ রাখলে না সুবিধা হতো তো এটা
Yes. Clearটা হচ্ছে by which recruit the petitioners by same way.
ওইটা হচ্ছে আর্ট স্কিল অ্যাপয়েন্টমেন্টে মানে কোর্টের অ্যাপ্রোচ
না
করাপশন নেই
You are the board.
Yes.
You are the board.
Yes.
You are trying to
Justify my action. Justify my actions.
to authenticate the steps you have taken.
Right. Right. Right.
So, in your limited domain, what will be the thrust of your argument?
Well, my basic thrust of the argument.
Writ petition, your selection which you made has been upset. But the loss of job is of the other persons
Right.
who are.
Right. Right.
So,
Yeah.
on that basis, what is your argument?
Milord, I, as the board, Milord, I have undertaken a recruitment drive.
Show us that the recruitment process which you have undertaken has been in consonance with the rules.
Milord, before that, Milord, may I please, before your lordship, Milord, judgments which deals with or which deal with, Milord, what is the approach of the court or what is the scope of judicial review in respect of recruitment drive where thousands and lakhs of
Ye-
people are concerned. Milord, here, Milord, 1,20,000 candidates participated. Appointments given to 49,000 and 42,000.
1,25,000.
20. 1,20,000. Some 1,20,000 odd.
Party, how many were the vacancies?
42,700 and odd.
42,900 odd. Yes. So in a selection process of such a nature,
Such a nature, Milord, what is the scope of interference by writ courts? Milord, the first judgment on this, Milord, amongst other, I won't say the first judgment, is Shodanando Hello's judgment, Milord, of 2008 volume 4 Supreme Court cases 619.
Justice Sirpurkar.
This is, yes. Well, my Lord Justice Chakraborty had the occasion to consider this in the
Yes.
civic volunteers case.
Yes.
This case also.
পরে 2017 এসিস অনলাইন ক্যালকাটা 379
Yes. Six one. Paragraphs.
Milord, I'll be relying on a lot of paragraphs. It would start from para 30 because all sorts of allegations were made. That's why. Milord, please note down the paragraph number, around 10 paragraphs, not many of those.
We shall go through it, Mr. Dotto. You can do
Very well.
it a short.
Yes, very well. Please take me paragraph 34.
You will be placing paras 34 to.
Milord, I'll be placing paragraphs 34, 36,
Yes.
37,
Yeah.
41, 49, 52, 56, 58, 60 and 62. About 8-9 paragraphs. But I'll just hurriedly place those, Milord. I've only selected only those, Milord, which
Yes.
however, since the courts below referred to the other defects in the selection process, we would take a stock of those findings. It was firstly urged by way of a complaint against these interviews that the dates were changed, and that was done in order to meet the political goals on the part of some leaders. We do not think that this complaint was justified. Firstly, there were no proper pleadings with necessary details before the learned single judge. Secondly, how the postponements affected the selection process is nowhere displayed. And further, which political leaders were responsible for such postponements of the interview dates had also not been pleaded. On the other hand, it was found that the records were found from the records that the postponements were on account of Asian Car Rally, Kali Pujo, Diwali, and Eid festivals. If that was so, we do not find any reason to hold against the selection process. And indeed, though we find some murmur in the judgments appeal against, we do not see any definite finding that such postponements affected the selection process. The very fact that there was a huge turnout in the district suggests the hollowness of the claim we therefore. So one of the allegations was postponement of dates. Now kindly take, Milord, para 36. We are therefore left with only one major contention regarding the enormousness of the number of candidates interviewed and the possible inability on the part of the interview board to complete the interviews in a proper manner. We would therefore proceed to consider this aspect in details. The basis of the contention regarding this factor made by the writ petitioners was the paucity of time. Based on such factors like the available time, the general requirement for assessing an individual candidate for the post of constable, the number of persons available for holding the interviews, the learned single judge had come to a finding that every board on one day could at the most interview 250 candidates. The division bench also seems to have endorsed the view. We have very carefully examined the contentions raised by the appellant's hearing and also the materials provided by the state through its counter affidavits, as also the plea raised by the officers who actually held the interviews in respect of the 3 districts of so and so. But before we go into the exercise of considering the situation in the 3 districts individually, we must consider the benchmark fixed by the learned judge at 250 candidates per day. We are afraid we cannot uphold that finding. The learned single judge as well as the division bench seems to have proceeded more on imagination than reality. Such a benchmark could not have been fixed generally, and only because that benchmark was allegedly breached, the selection could not have been found fault with in a mechanical and mathematical manner, instead of testing the matter on the basis of ground realities for each district on the basis of materials made available by the state. A mechanical approach, in our opinion, could not have been taken by the High Court. So, but this is made on the other aspect. The third is, kindly take me note, paragraph 41. But here, my lord, in our case, the judge, Honorable Court, my lord, proceeds on the basis that aptitude test was not taken. Whether or not it was taken, I'll demonstrate. But assume for argument's sake, it was not taken. Then, my lord, what should be the my lord, approach of the court? The question of large number of candidates appearing for selection process again came up before this court in Joginder Singh. A complaint was made in this case that 323 candidates appeared for the test in 2 days, and on that basis a select list was prepared by the Departmental Promotion Committee. The High Court called this selection process as a farce. Made in our case also almost similar finding, on the ground that fair chance was never given to the candidates to show their worth. The court observed in paragraph 5 as under. On the facts on record, we see no justification for the High Court to have come to this conclusion. The High Court, in exercise of its jurisdiction under Article 226 of the Constitution, is not supposed to act as an appellate authority over the decision of the Departmental Selection Committee. If the committee has been properly constituted, as in this case, and the post is advertised, and the selection process known to law, which is fair to all, is followed, then the High Court could have no jurisdiction to go into a question whether the Departmental Selection Committee conducted the test properly or not, when there is no allegation of malafide or bias against any member of the committee. Merely because there were a large number of candidates who appeared on 2 days cannot ipso facto lead to the conclusion that the process of selection was a farce and fair chance was not given. Normally, experienced persons are appointed as members of the selection committee, and how much time should be spent with a candidate would vary from person to person. Merely because only 2 days were spent in conducting the interviews for the selection of class 4 post cannot lead to the conclusion that the process of selection was not proper.
Yes.
Then, my lord, the next paragraph is paragraph 49. Then kindly take note paragraph number 49.
Yes.
Kindly see paragraph 49.
49, yes.
Where your lordship recollects, my lord, here one of the allegation is that the persons who had lesser marks in academic qualification has been granted higher marks in viva-voce or interview and aptitude test. 49. Learned single judge in his judgment has observed that as per the report of the amicus, the selected candidates got higher marks in viva-voce ranging between 30 to 41 marks. In our opinion, this has hardly any effect This is what the Supreme Court is saying. And merely because the selected candidates got higher marks ranging from so and so, that by itself could be no reason to reject this election. We have extensively referred to the comments made by the learned single judge on the earlier part of the judgment, where the learned judge has in fact recorded his satisfaction for the printed charts and more particularly about their authenticity. The learned judge had also expressed his satisfaction with the procedure adopted. There is hardly any reason given by the learned single judge accepting that the benchmark of 250 candidates have been crossed. But what the Supreme Court says is of no significance becomes the foundation of the judgment under appeal before your lordships. Then, my lord, your lordships may kindly take para 52. The para 52 is dealing with the impossibility with the time factor.
Yes.
Para 52. It is then asserted that in all 5540 candidates appeared between 3rd December to 8th December, and interviews were started at 6:30 a.m. and lasted till 8:30 p.m., giving clean 14 hours to the selection committee. It is pointed out that out of 5540 candidates, 1815 candidates were selected on being eligible, physically fit to appear for viva voce. It is then pointed out that the candidates who were left out of the viva voce due to shortage of time on the date of selection were called on 1910, 9/12/24 and 2004 and 10/12/2004 also. It is asserted that this fact was reflected on the police radiogram dated so and so, and only the selected candidates were called to appear for personal interview on the dates fixed on so and so. These fixed dates were such and such, and as has been submitted between so and so. It is very frankly contended in the counter affidavit that those who were left out due to paucity of time were called on so and so. The counter also goes on to explain that the interview board was alive to the consideration of the required selection of the post of constables, and as such, it was sufficient to test the candidates on the basis of their physical capability and agility. It is then contended that in viva voce, random questions were put to the candidates considering the time constraints to ascertain their minimum intelligence level, which a constable is required to possess, the copies of etc. So, paucity of the time, which prima facie appeared to be a deterrent factor in assessing the suitability or the eligibility of the persons. Again, has been highlighted over here, and the Supreme Court deals with it. Then 56, 58, I skip over for the time being. No, 58 now. 56 might I skip over. 58 is very important for me. But what is yes. And who were examined? Some of the petitioners and the interviewers, some of the interviewers. But here, my lord, the Supreme Court says that even the report of the amicus cannot be looked into. Even the report of a scrutiny team cannot be looked into.
Yes.
And in our case, my lord, the court had taken upon itself the burden of a prosecutor. I consciously use this expression prosecutor because I have a point of predisposition.
Yes.
But may I read further? While testing the fairness of the selection process, wherein thousands of candidates were involved, the High Court should have been slow in relying upon such microscopic findings. It is not for the High Court to place itself into the position of a fact-finding commission. That too more particularly at the instance of those petitioners who are unsuccessful candidates.
Yes.
But the first is the bar to undertake this kind of an inquiry, roving inquiry. And second, what is more important is at whose instance? At the instance of unsuccessful people.
Yes.
The High Court should therefore have restricted itself to the pleadings and the say of the respondents. Unfortunately, the High Court took it upon itself the task of substituting itself for the selection committee and also in the process assumed the role of an appellate tribunal, which was in our opinion not proper. Thus, the High Court converted this writ petition into a public interest litigation without any justification. Milord, where, Milord, the court had only appointed amicus and a scrutiny team and had decided the matter on those two bases, Milord, the Supreme Court is coming down heavily on the High Court. And what is my case? My case is the judge had become the prosecutor. This paragraph 58 clinches all points. Roving inquiry, unsuccessful candidates, substituting itself into a fact-finding tribunal.
Mr. Dotto, is it possible for a participant at the time of filing the writ petition to ascertain what you have done in your chambers? You have prepared this interview issue, which you are saying he acts himself as the prosecutor. We are wanting to get an answer from you. You are heavily relying upon the averments made. What more the averments could have been made by the participants?
Milord,
they say there is a scam, and these are the examples of it, some which you have relied, para 11 and 14. What we want to know is, seeing it from the perspective of the participating candidate, is it possible for him to ascertain what the board has done in its meetings, who have been appointed, whether any, what would be your answer to, because this would be their argument in counter.
There are two things. First is, Milord, there is a difference between a scam and a corruption.
We are awaiting to hear what
yes, I'll come to those. Scam was not a case made out.
Then, Mr. Dotto, you finish this up and come to the topic.
Yes. But two judgments on this,
yes,
and then, Milord, on the corruption aspect, Milord, I can appreciate, Milord, it's troubling the court. I can quite appreciate. I'll immediately take the corruption as my next point.
Then you have showed us paragraph 60.
58 was the last paragraph I placed.
You want to place 60 and 62.
60 and 62.
Yes.
In our opinion, the first basic thing for such a selection process would be lack of bona fides. This is the clinching issue. Lack of bona fides, or as the case may be, malafide exercise of powers by those who were at the helm of the selection process.
Yes, this is what.
This is the only, Milord, exception that the Supreme Court makes.
We want to hear you on that.
Yes, there is no allegation of malafide. no case made out of lack of bona fides and malafides. That couldn't have been, because the people over here are coming for an employment. I cannot say that the process is malafide and then say, give me employment. Those two cannot go side by side. These cannot go parallelly. Therefore, when a petitioner comes saying that X have been appointed, I stand on the same footing, I should also be given appointment, then it cannot be said that X has been appointed through a malafide process. He has to say that the process by which X has been appointed is correct, but I have been discriminated in that correct process.
No, that in fact leads to their submission that unless you cancel those appointment, how we get in?
No, that is not the case. Very well, I'll address your lordship on that also. I'll address your lordship on that also.
Yes. All right, we ask.
Yes.
Now paragraph 62.
60 minute, the third line. Both the courts below have not recorded any finding that they found any malafides on the part of any of the state officials who headed the interviews. On the other hand, the tenor of the judgment showed that the whole process did not suffer from malafide, lack of bona fides, bias or political interference. But these are the parameters, my lord, set down by the courts, because otherwise, my lord, all recruitments will be susceptible to all kinds of suspicion. My lord, unsuccessful people, my lord, have a tendency to point fingers at the process. Everywhere it is the same.
Yes.
That is why, my lord, your lordships have held in innumerable judgments that unsuccessful persons should not be entertained in before the court unless a very, very strong case is made out.
Yes.
Then, my lord, in Union of India versus Vikas Konar, when a selection committee recommends selection of a person, the same cannot be presumed to have been done in a mechanical manner in absence of any allegation of favoritism or bias. A presumption arises in regard to correctness of official act. A party who makes any allegation of bias or favoritism is required to prove the same. It is their burden. And in our case, my lord, the court takes up the burden.
Yes.
In the instant case, no such allegation was made. The selection process was not found to be vitiated. No illegality was brought to our notice. Therefore, my lord, the immediate query of the court is answered, my lord, in Bikash Konar's case. That one who alleges bias, malafide, corruption, XYZ, the burden is on him to prove. It is not for the court to make a roving inquiry. And these allegations, my lord, if they are made in the vacuum, with the catch expression corruption, the catch expression scam, then your lordships would be burdened with all kinds of litigations.
Yes.
Then kindly take me to the last paragraph of this judgment, para 52. 62, I'm sorry, 62.
Yes.
We have already shown in the earlier part of the judgment that there were proper advertisements. In our case, no dispute on that. Reasonable procedure was chalked out in the earlier meetings, held by the authorities. Even the guidelines were defined, like 2016 recruitment rules, and interviews proceeded along with those guidelines. A mere expression of doubts only on the ground of large number of candidates appearing and there being not objectively and properly tested without any further material, in our opinion, cannot by itself render the whole selection process illegal. But what is the case? No aptitude test was taken at the highest. At the highest, the case is that no aptitude test has been taken. Though it is not. Assume it to be correct for the time being. But the Supreme Court says that that by itself does not render the whole selection illegal.
Yes.
But I can understand no advertisement made. I can understand interviews were fixed on X date, it was taken on Y date. People could not participate. I can understand, Millard, there were lack of interviewers. I can understand fourth class staff conducting the interview. Something of that sort. So at the highest Millard, with all the roving inquiry, what the court comes to the conclusion is that aptitude test has not been taken.
Yes.
Therefore, Millard, this is what Millard, the Supreme Court lays down the parameters in where large number of candidates for large number of posts are conducted, recruitment process is conducted. Millard, only exception is malafides, lack of bona fides against officials. Where the Supreme Court did not use the expression identified officers. Kindly permit me to use the expression identified officers. You cannot say officers of the board. You have to point out someone. And that is what, with respect, the judge wanted to do. He wanted the previous president of the board to be called from the custody at 3 o'clock and cross-examine him.
Yes.
Well, the entire Millard, the writ, with respect, kindly do not take me amiss. The entire writ jurisprudence has been rewritten in this case.
Yes. Next.
Well, what your lordships have prohibited all along is what has been adopted in this case. Now, kindly take note a later judgment on the same lines, 2023. अच्छा ना अच्छा दी दे मतलब this अच्छा दी दे मतलब this Sadananda hello was also followed in our High Court, Millard, in 2017 SCC online cal 3799. So this is that civic volunteers case, Millard. The learned single judge, Millard, had passed orders, Millard, interfering with the appointments. Went up for appeal.
Yes.
Please take Millard paragraph 10. But we have to confine ourselves to the law which has been laid down by the Supreme Court.
Yes. Yes.
He further submits that no malafide has been alleged against the successful candidates and the learned judge erred in interfering with the decisions of professionally qualified authorities. The court has conducted a roving inquiry on the factual aspect which is not permissible. While testing the fairness of the selection process, wherein thousands of candidates were involved, the learned judge should have been slow in forming an opinion as regards the entire recruitment process on the basis of the manner in which the selection process was conducted in 2 police stations, and that too without granting any opportunity of hearing to the candidates selected in this process. Candidates are not parties over here, the 36,000 persons.
Yes.
In support of such contention, reliance has been placed on so and so. Then please take me to paragraph 18.
This we will go through, Mr.
Yes.
Paragraph 18.
Yes. Heard the learned advocates appearing for the respective parties and considered the materials on record. It is well settled that even though the power granted to the executive authority is not totally immune from judicial review, but the court makes an almost extreme presumption in favor of bona fide exercise of such power. Bona fide exercise of such power. The 2 indispensable riders for scrutinizing the validity of a recruitment process conducted by the government are to prevent miscarriage of justice and to secure fair play in action. It is the impact of the action that would define the nature of the procedure that is to be adopted. On one hand, the civil consequence of an order, particularly one that visits the person with the harsh consequences of his engagement being cancelled. And on the other hand, Miller, to be very honest, Miller, this part I will not argue because this is for the affected persons. But since it is a fallout of the previous discussion, therefore I have just read it, a part of it, Miller, the rest I will not place. I'm sure, Miller, the learned councils would place those. Then kindly take para 23.
Yes.
In the pleadings, this is our High Court holding. There is no allegation of malafide on the part of any state officials.
Yes.
But I use the expression identified officers. Here, Miller, our division bench has also said so. No allegations of malafide on the part of any state officials who were in the interview board. There is also no allegation of any bias or favoritism. The recruitment process was set aside since it appeared to the learned judge that it was an impossibility on the part of the selection committee to interview 1351 candidates at so-and-so police station and so-and-so candidate in so-and-so police station, respectively, on a single day. Before arriving at such finding, the learned judge did not perhaps notice the contents of the order of 28th of April, in which it stood recorded that the petitioner says that he participated in one of the group interviews. That is in the fact of that case. In the case of Sadananda Hello, it has been observed that no benchmark can be set as regards the highest number of candidates to be interviewed on a single day. It depends upon the post for which such interview is conducted, the nature of the duty attached to that post, the nature of the test to be applied, and other ground realities. The learned judge, while setting aside the recruitment process in the police stations at so-and-so, issued directions towards the annulment of engagement of CPVs all over the state, subject to an inquiry to be conducted by the committee. The last direction was supplemented by a further direction that all engagement of CPVs in the rest of the state cannot be extended beyond the state calendar year. This rider supplemented renders the decision towards the constitution of a committee and holding of an inquiry by the state committee to be an ideal formality. In the absence of any specific or categorical finding supported by any concrete and relevant material, that widespread infirmities of an all-pervasive nature, which could be really said to have undermined the very process itself in its entirety or as a whole, there was hardly any justification in law to interfere with the engagement of 1,30,000 CPVs all over the state at the instance of 9 unsuccessful candidates, and that too 3 years after such engagements. From the nature of the directions contained in the impugned order, it appears that the learned judge has treated the matters as public interest litigation. It is true that then it's not
Yes,
required,
yes.
so and so.
Next, Mr. Dotto.
Therefore, this is the only exception. In our case, I will, if required, once again take your lordship through the petition, no allegations of malafide.
Yes.
Now, kindly see, Lord, a later judgment of 2023.
Same point.
Same point with the addition that permissibility of judicial review. 5 paragraphs. No. This is 2013. 2023, volume 17, Supreme Court cases, page 147.
Paragraphs.
Miller, paragraphs 21.3, 21.6, 21.8, 39 and 40.
Yes. We shall go through it, Mr. Dotto. The paragraphs we have taken note of. You need not go through all the paragraphs.
Well, please permit me to read on the judicial review aspect. The other parts are, my lord, is what was held in Sadananda Hello. Kindly take me at para 31. Same judge.
Yes.
Before proceeding further, where the heading is selection process for public employment interference by court. Before proceeding further, it is necessary to preface our judgment with the view that courts in India generally avoid interfering in the selection process of public employment, recognizing the importance of maintaining the autonomy and the integrity of the selection process. The courts recognize that the process of selection involves a high degree of expertise and discretion, and that it is not appropriate for courts to substitute their judgment for that of a selection committee. It would be indeed treading on a thin ice for us if we were to venture into reviewing the decision of experts who form a part of a selection board. The law on the scope of extent of judicial review of a selection process and results thereof may be understood on consideration of the following case law. In Dalpat so and so, Miller paragraph 12 of quoted.
We shall go through it. We shall go through.
Miller para 32, kindly Miller have a look to para 32, para 33, para 34. These are all the judgments where on Miller public employment. Then para 35. Yes. Then para 36, judicial review part. Thus, the inexorable conclusion that can be drawn is that it is not within the domain of the courts exercising the power of judicial review to enter into the merits of a selection process, a task which is the prerogative of and is within the expert domain of a selection committee, subject, of course, to a caveat that if there are, but this is the caveat, if there are proven allegations of misfeasance or violation of statutory rules, only in such cases of inherent arbitrariness can the court intervene. The exception is also given. One exception here, Lordship had found in Sadananda Hello. The other exception over here is malfeasance and violation of statutory rules.
Yes.
Thus the court, para 37. Thus the court, while exercising power of judicial review, cannot step into the shoes of the selection committee or assume an appellate role to examine whether the marks awarded, but this is very important. But one paragraph here, Lordship remembers, kindly recollects, that high marks were given in Viva-voce.
Yes.
This is where, my lord, the Supreme Court speaks otherwise. And examine whether the marks awarded by the selection committee in Viva-voce are excessive and not corresponding to their performance in the test. The assessment and evaluation of the performance of candidates appearing before the selection committee interview should be best left to the members of the committee in the light of the position that a court cannot sit in appeal against the decision taken pursuant to a reasonably sound selection process. But kindly mark, Miller, this phrase, reasonably sound selection process. The following grounds raised by the petitioners, which are based on attack of subjective criteria employed by the selection board interview panel in assessing the suitability of the candidates, namely the candidates who have undergone post-graduation, has had been awarded 10 marks, and in the Viva process, such PG candidates have been granted 18 marks or 20 marks out of 20. That although the writ petitioner had performed exceptionally well in the interview, the authorities had acted in an arbitrary manner while carrying out the selection process, would not hold any water. So arbitrariness again doesn't hold water. Then, my lord,
39 and 40.
38 is also important, kindly see. All these aspects have been gone into. The next aspect of the matter which requires consideration is the contention of the petitioners to the effect that the entire selection process was vitiated as eligibility criteria enshrined in the advertisement. Notice was recast vide a corrigendum without any justifiable reason. In order to consider this contention, regard may be had to the following case laws. Again, 38.1 says unsuccessful candidates not to be entertained.
Yes.
But the entire 38, my lord, your lordships would find, my lord, number of judgments considered by the Supreme Court, and in 39, the Supreme Court says that having taken part in the selection process without demur, someone cannot challenge.
Yes.
And finally, my lord, Shodananda Hello has been followed at para 40. Which says that the only exception is malafidez. Now, my lord, I come to, my lord, the point which is possibly troubling the court, corruption. I start from the writ petition. The pleadings of corruption, my lord, are at paragraphs
Paragraph 18, I think.
12. Pleadings of corruption are at paragraphs 12, 14, 15, 17, 18, and 22.
Yes.
Let us see, what is the case made out of corruption. First is para 12.
Yes.
Your petitioner state that recently the TET 14 scam busted in West Bengal, and from several cases lodged by CBI and from several orders passed by this court, the petitioners came to know that several illegal appointments have been given, depriving the petitioners. Non-trained candidates are the worst sufferer of this scam. On 23/12/2020, the West Bengal so-and-so published one notification for recruitment of so-and-so primary teachers. Of so-and-so, and in that publication, they have stated that the candidate should possess the qualifications as per guidelines of NCT. The notification is absolutely illegal. As per qualification should be measured as on the date of qualifying TET 14. Strangely, in TET 14, candidates named as Mr. Y was impaneled. A person named Y having roll number so-and-so was impaneled by the board, and it also proves that huge corruption took place. As per the action of the board and as per different statements given by the then president of the board, all trained candidates were recruited, and as per the notification of the board, the petitioner should get a fair chance of recruitment, but the board has done a complete injustice to them. It is the stand of the board that non-trained candidates cannot be appointed. If it is the stand of the board that non-trained candidates cannot be appointed, then all appointment post March 2016 are bad in law. Board should apply same theory to everyone, and the board cannot simply pick and choose between the candidates. The petitioners are TET 14 candidates, and they deserve the same relaxation which was granted to other non-trained candidates. But two things that I would submit over here. This paragraph speaks of TET 14, so alleged corruption, and speaks of a recruitment process undertaken on 23rd of December 2020. We are not concerned about 2020 recruitment process. We are concerned about 2016 recruitment process. So the allegations of corruption are in respect of TET 2014 and 2020 recruitment process. We are dealing with a 2016 recruitment process. 16.
Yes.
But Milord, this person Y is of 2016. This I must tell the court. Then kindly take, Milord, para 14.
Yes.
This is the next pleading of corruption. Your petitioner states that at present, there is more than 1 lakh vacancy in the Education Department of West Bengal. Since 2011, several exams were conducted to fill up the vacancies in schools, but a single recruitment procedure could not be completed without corruption and irregularities. The qualified students were not selected, and the students who did not have any qualification were selected, and they were working in the department as teachers. So this is on the assumption that since the others were for other process were full of corruption, therefore this is also so.
Yes.
Then the next is, it is not their averment, I mean, not their statement, it is the statement of an MP. Para 15. Your petitioner further states that on so and so member of the parliament made a statement before the media pointing irregularities in TET panel. Recently, a person lodged a complaint against one MLA of so and so, alleging that the MLA took crores of money, crores of money from job aspirants with a promise to give them government job in school, and in that case, personal assistant of so and so MLA of so and so was arrested. The statement of so and so is described. So this is what they gather from the newspaper. Then, Milord, para 17. Your petitioner states that TET 14 is the biggest scam of the Education Department of West Bengal, and in this case, the ministers of the state of West Bengal, MPs, MLAs, leaders of the ruling party are involved, and meritorious students who qualified for the job did not get chance. And after talking to the candidates, the petitioners came to know that roughly 14 to 20 lakh rupees were taken for giving job in TET 2014. Some people did not get job even after giving the money, but they could not open their mouth due to threat of the members of the ruling party. Whatever it is of TET 2014, nothing to do with recruitment of 2016. Then, Milord, the next paragraph is para 18. Your petitioner states that the board has stated in different cases filed before this court that 42,897 candidates were selected till date, but no merit list of so and so were published. The board should be directed to publish, etc. The corruption part is a bit towards the end. Kindly take the last 3 lines of that page. Page 42. Persons who did not qualify for the TET 14 was appointed as primary teacher by the board, and in spite of specific case, steps were not taken, and it shows that there was corruption and illegal financial transaction while conducting the recruitment process. The department ought to have taken suo motu steps, but that was not done for the reasons best known to them. Moreover, many candidates complained that TET 14 qualified certificates were not issued to them, and even today they are fighting for that. There is no delay in filing the public interest litigation as corruption is continuing, and the Honorable Single Bench of this court also passed several orders regarding TET 14 in September 22, and absolute fraud has been committed by publishing merit list of TET 14 qualified candidates. Everything relating to TET 14. And they describe it as a public interest litigation. This is what the Supreme Court says, that you should not treat it as a public interest litigation. Then kindly take the last paragraph, para 22.
Yes.
Your petitioner states that since 2011, not a single recruitment was done by the state of West Bengal without any corruption and illegality. Time to time, this honorable court had to interfere, and still the same corruption is prevailing. The persons who were involved in TET 14 scam are holding different posts under the government of West Bengal, and the candidates who suffered due to the scam are facing hardship. The petitioners were subjected to complete injustice by the department. Your petitioner states that the respondents and each of them acted arbitrarily, etc. In appointing some candidates who did not even sit for the TET 14, and as such, this honorable court questions judicial.
Yes.
So confined to TET 14, the word corruption has been used out of context in my very humble submission, but we'll deal with that. Now, kindly see, my lord, the judgment of the honorable court on the corruption aspect. Then, my lord, I'll address the court. What is corruption? What is scam?
No, before that, you show us the process, selection process, the notification, and the procedure you follow.
Yes, that definitely I'll follow. I'll demonstrate. But, my lord, on the corruption aspect, this is the pleading and what is the finding of the court. Please have a look.
So that you have showed us that the court itself acted as a prosecutor.
Yes, that is one aspect. The other aspect is on corruption. What is the finding of the court? But the judgment starts at page 611.
Yes.
Now, please take me that internal page 9 of the judgment, running page 618, third volume.
Yes.
Third volume.
In support of the allegations
Yes.
of corruption.
In support of their allegation as to corruption, in awarding marks, in the interview, the petitioner has filed a booklet, spiral binding, of 121 pages, on the basis of which it has been alleged that candidates whose marks were very poor in secondary, in higher secondary, and in TET has been given 9.5 out of and 10, that is full marks, out of full marks, 10, that is perfect 10, in the interview and aptitude test. Then within bracket, no aptitude test was taken at all. And the allegation that there was no aptitude test, which has been proved before me from evidence of the candidates and from interviewers which are kept on record. Here, to elicit the truth, I had to exercise power under 165, but I'll address separately. Some particulars has been given in the said 121 pages booklet, spiral binding, which has been prepared from the particulars published in the web portal of the board. By the board, some candidates' marks are reproduced herein below, which shows that the marks awarded to such candidates whose results are very poor in secondary and higher secondary examination and also in TET are wholly absurd assessment in interview. And unless some extraneous factors, which include corruption, as has been alleged by the petitioners, and how has come to light from the investigation by CBI and ED, I do not know which report says so, but the court considers this, such absurd marking could not have been made by the interview boards in different districts. While looking to the following particulars, it has been noted by me that in academic assessment and TET, the maximum marks that could have been given is the same thing, 10 out of 10.
Now, where is this compilation of this 120?
Well, that is in the paper book, but Millard, this was not part of any pleading.
Compilation.
It's in our from the those pages also, keeping my point open that spiral binding could not have been looked into, but still then, since the judge honorable court has looked into it,
Yes.
now I give an example of a candidate where the court gives an example where in the entire judgment your lordship will not find where any submission of the petitioners, unfortunately. Now I give example of a candidate before giving a table prepared from the document on record, that is 121 page booklet. This candidate has got 2.866 in TET out of 5, 1.462 in secondary out of 5, and 3.050 in higher secondary out of 10, totaling to 7.378, but has been awarded 9.0 marks in interview and aptitude test not taken out of 10. Whose total score became 16.878 and thus became eligible for appointment as a primary school teacher. Huge number of such absurd awarding of marks has come to light through the said booklet prepared from particulars published by the board. Then we had a list. How many names have been given? 53. Only 53.
Yes.
But Millard, the honorable court does not take into consideration there are thousands of cases just the opposite. High marks in academics and low marks in Viva-voce aptitude. Is not looked into by the court. Where those papers are on record, I'll demonstrate from that when I take up this point on the aptitude test part. Then kindly skip over 2 paragraphs, kindly take para 17. So according to the court, 53 candidates granted high marks in Viva-voce.
For that the entire
The entire process should go. That is the approach of the court.
Yes.
Then please take Millard paragraph number 17, where I only draw your lordship's attention to the corruption aspect part. From the gross illegality in the selection procedure in the recruitment exercise of so-and-so conducted by the board, we're pausing here for a moment, Millard. There was no allegation of corruption in 2016. I've taken your lordship through the pleadings. Whatever corruption alleged, right, wrong, TET 2014. It is clear that the board and its officials, including its former president, who is now in custody after arrest by the Enforcement Directorate for transaction of huge money in the recruitment procedure, conducted the whole affair like affair of a local club, and now it is gradually coming to light by investigation of Enforcement Directorate that jobs for primary school teachers were actually sold to some candidates who had the money to purchase the employment. A corruption of this magnitude was never known to the state of West Bengal. The former minister, former president, and a number of middlemen through whom jobs were sold like commodity are now behind the bars, and the CBI ED investigation is being continued in full swing. This paragraph. It can come in this paragraph provided the judge is examined as a witness. 1871 Indian Appeals Made, I'm going to place.
Yes.
How can the court import its personal knowledge in the matter? Which CBI, which ED, which investigation? Where are those documents in the records of this proceeding?
Did you argue this in the appeal which was preferred against this order, interim order appeal? So this personal knowledge of the single judge was not argued, which you are.
No, that was interim order.
Yes,
This is the
interim
final
order.
one.
Judgment of Justice Subroto Talukdar.
Yeah, that was at the interim order stage.
Yes, yes.
Yes, yes.
That ground was not taken by you.
My lord, this is a point of law, my lord. I can take it even in a collateral proceeding, my lord. Even in a collateral proceeding, my lord, I can take it.
Yes, next.
Then kindly take paragraph 18. It is a matter to be noted that board in its affidavit in opposition while dealing with all pleadings of the petitioners, instead of addressing the allegation of corruption and illegalities in the recruitment process, raised some niceties of law and some principles of law, but however nice or however laudable those principles may be, this court as a court of justice will fail to deliver justice, knowing fully well that sense of justice is much above sense of law. If the writ application is thrown out on such niceties of law, as this will appear that in the name of preserving the law, the corruption would be protected, which a constitutional court can never do, keeping in mind the soul of our constitution and the constitutional conscience.
Yes, yes. You have placed this, Mr. Place this.
So constitutional conscience, I must say that in this recruitment scam, stinking rats are being smelled. The board placed some judgments before me in support of the niceties of legal principles, which I do not find have any applicability in the fact of the magnitude of stinking corruption in the recruitment exercise of 2016 conducted by the board. Those judgments are not required to be mentioned at all in the factual situation of the case, as those are bright stars of the space, much above the ground realities.
So you now want us to deal with your judgments.
No. I have
the judgments which we have cited,
yes,
before the learned single judge, that were
with
not,
respect, it is not even noted.
it was not.
If somebody tells me that no, you have not cited this judgment, I can't say anything.
Yes.
But the minimum that I can expect is the judge will at least note that so and so has submitted the ABCD judgments.
Is
yes,
it to
but
be
not
submitted? Mr. Dotto, Advocate General, argues it is to be submitted.
Yes. Then last paragraph, kindly take note, para 25.
Yes.
This whole imbroglio, including corruption involved in the matter, has taken place due to the former president of the board who knew the rules of recruitment but violated the rules, and therefore, if the government thinks the entire expense for holding of the recruitment exercise can be realized from the estate of such and such. So the corruption is infraction of the rules. Para 25 is very important. Finding is corruption based on infraction of rule.
Yes.
But now,
Yes.
Infraction of a rule can be an irregularity, can be a lapse, can be a departure, but it cannot be corruption. Now, what is corruption? And I'll place judgments on that. But simply saying corruption does not make it a corruption. The judgment of record. 7 7 আর 4 9. But please take my lord, Black's Law Dictionary, 10th edition. At the second page, my lord, page 421, please take the right hand side column at the bottom. But the meaning of corrupt is said to change someone's behavior, morals, or principles from good to bad, to pervert the integrity of, to change the traditional and established form of culture, language, etc., so that it becomes worse than what it was before, to destroy or diminish the quality and usefulness of an electronic or mechanical device or its component, archaic, to impose corruption of blood on a person. Now, what is corruption? Kindly turn the page. The left-hand side top.
Page?
With the next page, page 422. এই ভুল আছে নাকি?
22.
20 বললাম?
Which
No,
page?
Milord, there are two pages, 421 and 422.
Oh, you put my copy 21 given at the bottom. Yes.
Oh, I'm so sorry, Milord. I'm sorry.
Yes, corrupt.
But
No, it's okay. It's okay. Yes.
now please take Milord 422.
Yes.
Corruption is defined as depravity, perversion, or taint, and impairment of integrity, virtue, or moral principle, especially the impairment of a public official's duties by bribery. The word corruption indicates impurity or debasement, and when found in the criminal law, it means depravity or gross impropriety. Then two is a fiduciary's or official's use of a station or office to procure some benefit either personally or for someone else, contrary to the rights of others, an act carried out with the intent of giving some advantage inconsistent with the official duties or rights of others. This is, Milord, the traditional definition of corruption.
Yes.
The important or the relevant part over here in our case is impairment of public officials' duties by bribery. First is, Milord, here we do not have any identified public official. You cannot just say given money, taken money, sold job, given jobs to the less meritorious in a case of corruption. It has to be Mr. X found. First of all, Milord, this is not a proceeding in which this can be gone into. Be that as it may, Milord, fundamentally speaking, Milord, in a case of corruption, a person has to be identified and proved that he has indulged in corruption through bribery, illegal gratification, etc. Now, how, Milord, the expression corruption is being defined in judgments of the Supreme Court? Please take, Milord, 2000, or first kindly take 97 seat of 97 seat of উঠে 97 3 আরেকটা দাও পেজ 403 হ্যাঁ kindly first take 1997 volume 3 Supreme Court cases page 483 এই আরেকটা কপি আছে এই আমারই তো নেই না দাদা
আপনাদের এর মাঝে একটা বড় আপডেট দিয়ে রাখি, হাইকোর্টে ফের ধাক্কা খেলো। বিষয়টি হচ্ছে, আপনারা হয়তো অনেকেই জানেন যে সুপার নিউমেরারি মামলার কোনো স্বস্তি হলো না, কিন্তু এখানে এই মুহূর্তের সবচেয়ে বড় ব্রেকিং নিউজ, ব্রেকিং আপডেট, স্কুল সার্ভিস কমিশনের নিয়োগের জন্য যে অতিরিক্ত পদ তৈরি করেছিল তাতে অন্তর্বর্তী স্থগিতাদেশ বহাল ডাকলো ডিভিশন বেঞ্চ। কলকাতা হাইকোর্টের বিচারপতি বিশ্বজিৎ বসুর সিঙ্গেল বেঞ্চের নির্দেশই বহাল ডাকলো বিচারপতি সৌমেন সেন এবং বিচারপতি স্মিতা দাস, দ্য ডিভিশন বেঞ্চ। অর্থাৎ আপাতত কোনো নিয়োগ করা যাবে না বলেই নির্দেশ আদালতের, আপাতত কোনো নিয়োগ করা যাবে না বলে নির্দেশ।
And impetus and put premium on corruption. The society has to pay the price for corrupt officers for public exchequer. Therefore, when the court directs payment of back wages on reinstatement, the court tribunal is required to consider the backdrop of the circumstances and pragmatically apply the principle to the given set of facts. No abstract principle of universal application could be laid in that behalf. The confidential report of the officer prior to initiation of the prosecution do furnish evidence of conduct of the public official. It is the duty of the officer to place his material and of the government to place all other necessary records in that behalf before the court tribunal consideration, and it would be for the court tribunal to consider and decide the matter. This court has
back wages payment.
Yes, this is a back wages case, but two things are important over here. First, it says that it is an unsatiated greed for wealth, and again and again when I am saying that a public official has to be identified,
Yes.
and there has to be exchange of money, illegal gratification demand,
Yes.
and without handing over. Kindly take note of the next judgment of 2004-9 Supreme Court cases. 311. 2004 volume 9 Supreme Court cases 319. 319. Kindly take only one paragraph, paragraph 3.
Thank God. Yes.
Corruption as such has reached dangerous heights and dangerous potentialities. The word corruption has a wide connotation and embraces almost all the spheres of our day-to-day life and world over. In a limited sense, it connotes allowing decisions and actions of a person to be influenced not by rights or wrongs of a cause,
But by the prospects of
but by the prospects of monetary gains or other selfish considerations. Avarice in a common frailty of mankind, and while Robert Walpole's observation that every man has a price may be a little generalized, but it cannot be gainsaid that it is not far from truth. Burke cautioned, among a people generally corrupt, liberty cannot last long. Therefore, monetary gains and other selfish consideration is the other expression used by the Supreme Court. But our High Court in 1994, which is very important, I feel, for my case, is that specific instances of corruption has to be highlighted.
like fraud.
Yes.
Or apart than. Yes. Okay, party করতে হবে। Yes.
आगे कोनटा दिलाम 2004 but one judgment before the Calcutta High Court, please take me lord, 2007 volume 7 Supreme Court cases 358. 2007 volume 7 Supreme Court cases 358.
How many more do you have in your bag?
But this being the most important aspect, but about 7-8 on corruption.
7-8.
But 2007 volume 7 Supreme Court cases 358, only one paragraph. But this is AIR 1994 Calcutta 10. This is under 226. Please take only one paragraph. Yes. Paragraph 5.
Yes.
As regards the general allegation of corruption, as made by the petitioners, the same cannot be adequately dealt with unless specific instances of corruptions are brought to light.
You need to scam.
However, even general allegation of corruption and malpractices, if it continues to be consistently articulated for long, is likely to expose the concerned department to disgraceful suspension in public mind and thereby tarnish its credibility in the matter of discharge of assigned responsibility. In public interest, as well as in the interest of department itself, it is therefore highly desirable that the departmental authorities should look into the matter with circumspection for ascertaining whether there is any truth in the general allegations and to take steps to plug the loopholes of malpractices if there be any. The petitions are granted, etc. Therefore, my lord, there has to be specific instances of corruption.
Yes.
Then what is to be proved now? In an allegation of corruption, in a case of corruption, what is to be proved? But please have a look to this judgment of 2023, volume 4, Supreme Court cases 731 pages. শেষ হয়ে এসছে। But I'll place a few paragraphs of this judgment. Paragraphs 19, 37, 47, and a few subparagraphs from paragraph 88 and 76. 19, 37, 47, 73, 82.
Yes.
In P. Satyanarayana Murthy, reference was made to two cases, namely so and so. In the first of the aforesaid two cases, it was observed that the prosecution has to prove the charge under section so and so, like in any criminal offense, and that the accused should be considered to be innocent till it is established otherwise by proper proof of demand and acceptance of illegal gratification, which are the vital ingredients necessary to be proved to record a conviction. In C.P. Rao, which is the second of the two cases referred to in so and so, it was observed that this court, by this court, that mere recovery by itself would not prove the charge against the accused in the absence of any evidence to prove the payment of bribe and to show that the accused had voluntarily accepted the money, knowing it to be bribe, the conviction could not be sustained. Then, my lord, the next is para 37. There has to be demand and delivery.
Yes.
That the presumption under section 20 of the Act would apply only if the fact of demand and acceptance of illegal gratification, as the case may be, is proved. Such a proof can be adduced even by way of a circumstantial evidence in the absence of direct evidence. This would be so particularly in trap cases, as the prosecution has to prove that the accused had demanded a bribe from the complainant. The factum of demand can either be proved by direct evidence or through circumstantial evidence. Then, my lord, para 47. Well, in para 47, my lord, the provisions of the Evidence Act is considered, but I'll take it separately. For the time being, your lordships may skip over para 47. Now, please take para 76. P. Satyanarayana Murthy has been referred to in the state of so-and-so by observing that what constitutes illegal gratification is a question of law. Whether on the evidence let in, crime has been committed or not is a question of fact. If therefore the evidence regarding the demand and acceptance of a bribe leaves room for doubt and does not displace wholly the presumption of innocence, the charge cannot be said to be established. The court also made observations regarding framing of a charge in a criminal trial, where the court is expected to apply its mind to the record and documents placed therewith before the court. It was also held that a proof of demand is an indispensable mandate for the offense under section 7 and 13 of the Act. On the facts of the case, it was held that the same was absent and the accused was liable to be acquitted. Then a few subparagraphs from para 88. What emerges from the aforesaid discussion is summarized as under: A. Proof of demand and acceptance of illegal gratification by a public servant as a fact in issue by the prosecution is a sine qua non in order to establish the guilt of the accused public servant. Then 3. Further, the fact in issue, namely the proof of demand and acceptance of illegal gratification, can also be proved by circumstantial evidence in the absence of direct oral and documentary evidence. In order to prove the fact in issue, namely the demand and acceptance of illegal gratification by the public servant, the following aspects must be borne in mind, but I don't trouble the court with those aspects. Then E, when inference can come in. Please stay 88.5. Well, it may be said that I don't have any evidence before me. The court should infer. When should the court infer? Kindly take 88.5. The presumption of fact that with regard to demand and acceptance or obtainment of an illegal gratification may be made by a court of law by way of an inference only when the foundational facts have been proved by relevant oral and documentary evidence and not in absence thereof. On the basis of material on record, the court has the discretion to raise a presumption of fact while considering whether the fact of demand has been proved by the prosecution or not. Of course, a presumption of fact is subject to rebuttal by the accused. In the absence of rebuttal, presumption stands. Therefore, my lord, the court needs some foundational facts also. Just pointing fingers is not foundational facts. Just assumption that everything was bad, therefore this is also bad. These are not foundational facts. And what is the corruption alleged or found finally? Departure from the rules. Therefore, the first question which would arise for your lordship's determination is, going by the findings of the court, that there has been a departure from the rules. Let us take it to be a deliberate departure. Let us for the time being assuming it to be a deliberate departure. Though I don't accept it, I will prove that there was no departure. Presume for argument's sake that there is a deliberate departure. Where is the allegation of exchange of money? Where are those foundational facts? Therefore, my lord, my one-line answer is, or one-line submission is, a departure from a recruitment rule, proved or otherwise, cannot tantamount to corruption.
Yes.
But there are two 2025 judgments on vague allegations. These are just vague allegation, assumption. That was bad, those were bad, so this is also bad. But everybody is swayed by this expression corruption.
Are you required to place those because you have placed Niras?
Which are just my lord, on the vague allegation, because my case is that your lordships have seen the pleadings. My lords have also gone through the judgment on the corruption aspect.
You can give the citation
Yes,
to
yes.
those.
My lord, the first one is 2025 SCC online SC 17 paragraph is 13
And the other one?
The other one is 2025 SCC online SC 441 para 22.
Yes.
Kindly see, my lord, here the Supreme Court says in the first one, that is page 17, para 13, just one sentence. Please take the second sentence at para 13. That apart, besides the vague allegations, rest of them, even if they are taken as true, would not disclose commission of any offense or make out a case against the appellant. But these are, my lord, against, my lord, identified officers, pointing allegations against named persons, FIR registered. Then also Supreme Court says vague allegations do not constitute corruption. Please take the last one.
Para 22.
Paragraph 22. Where the allegation over here is misuse of authority. The erstwhile president of the board has been, remarks have been passed against him. Kindly similar there, paragraph 22. The only charge is with respect to misuse of authority, which does not come under the provisions of the Prevention of Corruption Act, and none of the ingredients regarding demand or obtaining or acceptance of bribe or any illegal gratification has come out. The accusation was only that the policy of the state required a tender process, etc. My lord, kindly take the next page. The investigation report, as we observed, speaks only of an allegation of misuse of authority without any allegation of demand and acceptance of bribe as against the appellant. The presumption of section 20 is false. The misuse of authority is again not a corruption. There is no allegations of demand and acceptance.
Yes, Mr.
My lord, would your lordship permit me to come back after the vacation? Before the vacation is very difficult. It's really very difficult. I know, my lord, it's a
Mr. Dotto, we have allowed you to place all the judgments. We do not want to shut it off, but How more time will you be taking?
But I'll take at least 2 second halves.
You said 1/2 is enough.
No, it's not enough. The more I read, I find, well, I've not even canvassed 2 of my 10 points.
You will get a chance to reply,
No,
no?
but unless I place it, they don't get a chance to rebut.
It becomes an impossibility to finish it off.
The problem is, Millard, the way this matter has been dealt. I'm so sorry to say, Millard, after conclusion of hearing of the petitioners, then, Millard, I begged and got an opportunity to file an opposition. And I take responsibility of saying, Millard, kindly do not take me amiss. It may not sound proper, fair. But the petitioners did not utter a single sentence in which are reflected in the judgment.
You are for the petitioners.
No.
I am for an additional party, which is already under. I am for that
No,
party.
Who are the petitioners? So, Mr. Mojumdar, how much time will you take? Because we are not being to fathom it out, because the arguments which have been advanced, these you must have to deal with it. No?
We will deal.
How?
There are,
Mr. Dotto, please.
with the candidates, there was a specific direction by the Honorable Supreme Court also, since we are not heard.
Yes, we have seen that. We are not saying we will not hear you. This order is with us. You have placed it before us.
But kindly keep it after the vacation. Give me 2 days more, I'll finish.
Yeah, Mr. Dotto, curtail it to a single day. Mr. Don't take it. We just don't feel like stopping the.
No, I quite appreciate, but I appreciate the burden of the court also.
Please. I would say you agree to dates. You give us a fixture. My brother is here. We will fix it up and finish it up. Because I don't know whether how.
Honored councils representing the added parties won't be making their submission except 1 or 2. That's what.
No. First of all, after he finishes, we want to hear the writ petitioners.
I was suggesting this, but since all of them would be selling on the same board, worship hears whosoever supports the appeal, so that I can give a comprehensive reply.
And Mr. Bhattacharya, I am led by Mr. Bhattacharya. Mr. Bhattacharya, to only take 1 hour.
You are appearing for whom? The added person.
Supporting the writ petitioner, which is already allowed in as a form of can 2, added respondent. Added respondent.
The added respondent.
Yes, my lord.
No, not at all. Not added.
My lord, in can 2, in the first order, I have added. Kindly read it. And they never opposed in the way of affidavit. But that was the direction on the first order.
We know, we have been told, Supreme Court has said, we will listen to you, sir.
They are saying that we stand on the footing of the writ petition. It is not that case.
The primary argument would be by Mr. Mojumdar.
And I will,
By Mr. Mojumdar.
yes.
And if any additional point to that effect is argued, we will allow you to reply to this. Tell us that. Tell us that.
What? They decided from this side.
I don't know, we have not checked up the order sheet whether you have been added.
Yes. My lord, kindly say can 2, my lord. In the mat. Yes.
Can 2 was allowed by which order? What is the date of the order?
iPad. The first order. iPad. And the other can also, I am appearing on behalf of the. In MAT 873, can 2.
We don't know, you are appearing for the applicants, which can?
Can 2, can 7, can 22, can 40.
Any one of the cans have been allowed.
Yes, my lord. In the first order, can 2 is allowed.
Can 2 in connection with which?
MAT 873 of 2023. That means the board mat.
Board's appeal.
Yes, my lord.
So in the board's appeal, you have been
Yes.
So very good. We will hear you.
Yes, my lord. I am led by
Hear you.
Yes.
Then after Mr. Dotto concludes,
I will satisfy that.
we will just a moment. Wait, sir. After he concludes, we will hear you and he will give a composite reply to this.
Okay.
Mr. Modi.
Yes, ma'am.
That's it. Go, go.
My lord, my lord, my lord, after Mr. Dotto, my lord, after Mr. Dotto, Mr. Bandyopadhyay would like to make his submissions. It was submitted by him on the last occasion.
Yes. Let him finish, madam.
এই তো।
তাই তো আমরা করতে পারি কন্টিনিউটি চাই তো আমরা
Keeping it on 12th, but finish it off
Yes.
on that.
Kindly give me 12th and 13th subject
No,
to
no,
your
not
lordship's point.
12th, we request you, please curtail it. You tell us the paragraphs, we will go through the judgments, relevant portions, you come back and make an endeavor to finish it off.
Right.
And we save 12, and you be ready for your, you people be ready on 12th. We can take it up on as a continuing pathad on
Okay.
13th and 16th, and you finish it off. Mr. Bolinder, you have not yet started. You start.
Madam, I am appearing for one of the employees who have lost their employment. He might not wants the continuity and day after tomorrow, day after. I can continue the argument tomorrow.
For whom, Mr. Mitra, you are
I can. If whether one's continuity of the arguments before vacation also,
না না জজ সাহেবরা চাইছেন না এখন চাইছেন
I mean, cancel. Who are not parties but employment cancel. They are about 700 in numbers, so I am concerned. Is the case? If I that one, I can continue tomorrow.
Mr. Mitra, unless he finishes, how can we allow?
That's not giving a choice to your lordship.
Now again, then he
So,
will
we'll-
complete it half and again
No,
come
we
back
shall
and-
not, there will be no contradiction.
ছুটি পরে
So,
Yeah, আগের অর্ডারটা কি দিয়েছিল? আমাদের orders ছিল, আমি সব লিখেছি। Mr. Dotto, please finish it off on.
12 minutes.
ফার্স্ট হাফ নিয়ে নেবো ফার্স্ট হাফ নিয়ে নেবো
Sir, you find it out now. You assist us. You point out the dates of the order.
What the orders of understanding?
Orders, no, compilation of orders we also have. But the thing is, which order you are referring to? Please check it up. Or Mr. Dotto, the next senior advocate, appearing for the evidence. Is the matter for further consideration? For further consideration on কত বলেছি? On 12 June as fixed at এই যে জাজমেন্ট যে করেছে না অর্ডার শিট আর এইগুলো এই কারা কি বলছে তুমি এটা নোট করেছো? অ্যাপ্লিকেশন গুলোর কি আলাদা বান্ডিল আছে? তাহলে ওই অ্যাপ্লিকেশন গুলোকে একটা আলাদা বান্ডিল করে চেম্বারে রাখো, তাহলে দেখে নিতে হবে আমাকে।
বলছে অফিসারকে বললো মনে হলো আন্দামান যাবে কেউ
12th June, 12th at
কবে লাগবে?
আচ্ছা, আপনারা এখনো যারা লাইভে আছেন তাদের জন্য বলি, কি বলবো বলুন, বোর্ডের এখনো বলা শেষ হয়নি। আমাদের কোর্টের এখনো বলা কোর্টের এখনো বলা শেষ হয়নি, বুঝতে পারলেন? কোর্টের এখনো বলা শেষ হয়নি, আমাদের বোর্ডের এখনো বলা শেষ হয়নি, বুঝতে পারছেন? বোর্ডের এখনো বলা শেষ হয়নি, বোর্ড আরো বলবে, বোর্ডের মন ভরেনি, বুঝতে পারলেন তো? বোর্ডের মন ভরেনি, মানে বোর্ড বলে শেষ করতে পারেনি, আরো বলবে। এবার বোর্ড আজকের মতো শুনানি তো এখানেই শেষ হলো। তো পরবর্তী শুনানির ডেট দেওয়া হয়েছে আপনার 12ই জুন, এটা সকলে জানতে পেরেছেন, 12ই জুন ডেট দেওয়া হয়েছে। আর ওই দিন পর্ষদের আইনজীবীকে 1 ঘন্টার মধ্যে তাকে শেষ করতে হবে। সে বহুত বলেছে, তাকে 1 ঘন্টার মধ্যে শেষ করতে হবে, এবং সে যে পরিমাণে বক্তব্য রাখছে তাতে বিচারপতি দেখলাম যে হয়ে যাচ্ছে, সে বলতে পারেন অনেকটা বিরক্তি প্রকাশ করছেন। একই জিনিস, একই বিষয় তুলে ধরছেন সময়টাকে লেন্দি করার জন্য। তো এটা যখন আবার নেক্সট উঠবে তখন কিন্তু আরও ডিটেলস আসবে। তবে এই সামনে হিয়ারিংয়ে 12 তারিখে যে হিয়ারিংটা আছে, 12 তারিখে যে ডেট দেওয়া হয়েছে জুনের 12 তারিখ, সেদিন আপনার এই কোর্টের বলা শেষ হলে তারপরে আপনাদের বিরোধী যারা আছে বা বিপক্ষে যারা আছে তারা বলবেন, তারপরে একটা কিছু আসতে পারে। তো আমি আজও বলেছিলাম যে আজকে হয়তো এই বোর্ড আজকে বলা বোর্ডের আইনজীবী বলা শেষ করবেন, তিনি আজও শেষ করতে পারেননি। তাকে টাইম দিয়ে বেঁধে দেওয়া হয়েছে যে সে তাকে 12ই জুন যখন হবে তাকে 1 ঘন্টার মধ্যে তাকে শেষ করতে হবে তার বক্তব্য। 1 ঘন্টার মধ্যে তার বক্তব্য তাকে শেষ করতে হবে। তো নেক্সট যখন আবার আপনার হিয়ারিং আসবে সেদিন হয়তো আমরা ভালো কোনো কিছু একটা জাজমেন্ট কিছু আসতে পারে, এটাই। আজকে তেমন কিছুই আসেনি। এটা হচ্ছে মূল বিষয়। কি বলবো বলুন, বড় খারাপ লাগে, এগুলো বলার নেই, এভাবেই চলবে। আমি বুঝতে পারছি নাকি বোর্ডের থেকে কি ইচ্ছাকৃতভাবে এইভাবে ডেটটাকে লেন্দি করার চেষ্টা করা হচ্ছে, সময়টাকে এক্সটেন্ড করার চেষ্টা হচ্ছে কিনা, প্রশ্নচিহ্ন রয়ে যাচ্ছে। আচ্ছা, মূল বিষয়। কিছু বলার নেই, খারাপ লাগে, খুবই খারাপ লাগে। এইভাবে চলতে থাকবে, আবার 12ই জুনের অপেক্ষা করতে হবে। 12ই জুনে কি হবে সে অপেক্ষায় থাকতে হবে, এছাড়া তো কোনো উপায় নেই। বলুন, এছাড়া কোনো উপায় নেই, অপেক্ষা করা ছাড়া কোনো গতি নেই, অপেক্ষা করতে হবে। অপেক্ষায় একমাত্র আমাদের এখান থেকে মুক্তি দিতে পারে, তাছাড়া আর মুক্তি দেওয়ার মতো কোনো পরিস্থিতি দেখতে পাচ্ছি না। ভয়ঙ্কর ভয়ঙ্কর।